May I please? Lordship, item number 58 of order, my lord. That the notice had to be issued, my lord, but severally it has been listed but could not be reached, my lord. So, as directed your lordship
After the motion?
after the motion, my lord. And my lord, regarding item number 38, my lord, admission, my lord, since the matter is very urgent, my lord, and my lord, regarding my construction, personnel house construction has been stopped, my lord. So can it be taken on 30th of November, my lord? Urgency is there, and small matter lordship may decide since
No, today what is the difference?
no, since the matter is listed at serial number 38, my lord.
Doesn't matter. Where are you mentioning now?
Lordship, as you please.
If we do not reach, if the matter doesn't reach, then you make a mention at the time of.
Lord.
May please, Your Lordship. I beg to mention an old pending repetition, my lord,
Of which year?
of 2012, my lord.
12. Okay,
Yes.
21.
My lord, next week, my lord. Obliged, Your Lord.
So we filed this repetition yesterday.
Motion.
Motion, Lord.
When?
Lordship, can it be today because the AGM is fixed on 26 is complete in complete violation of the office memorandum.
You're for a cooperative society.
No, I'm representing the shareholders of the cooperative society.
Well,
Lordship.
have you informed the other side?
Yes, Lordship. The copies have been served.
Okay. And inform also that you're trying to
Lordship.
move it on.
Lordship.
May I please, Your Lordship? I'm paying for listing one bid petition for
Admission. Matter of which year?
2023.
23. Where are you mentioning? When was it last listed?
17/3/2023.
17.3. What is the subject matter?
Withdrawal of PS.
But withdrawal of PS2. What is the urgency? Okay, we'll have it next Friday.
Okay.
May it please, my lord, I beg to mention an item for listing, my lord, for 28. There is an urgency pertaining to the matter, my lord. It is a tax matter, my lord. What had happened in the case is that fresh assessment was directed, my lord, by the assessment officer.
When are you?
My lord, 28, my lord, because 29, the fresh assessment will be conducted by the superintendent of Central VAT Audit Team, my lord.
Next week, it's not possible.
My lord, 29, my lord, Wednesday, otherwise the assessment will be conducted. I pray,
When was
my
it
lord.
last listed?
My lord, fresh matter, my lord.
Or read
First time.
Motion you can have.
Highly obliged, my lord. 28.
May I praise the Lordship? Lordship, I prefer listing of an highest will for stay vacating Lordship.
Next week, Wednesday.
Lordship, obliged.
May it please the Lord. Lordship, with the consent of the other side, I beg to mention item 35 of today's date.
Yes.
Lordship, instructions are awaited. I'm representing respondents 1 to 3.
Revenue
IOCL.
Department.
IOCL.
IOCL. IOCL name is not there. 35 deposit to submit. What is the name of the case?
My lord, Morzina. Sayada Morzina Khatun.
Not 35.
31, my
31.
31,
IOCL. Have you informed the other side?
my lord. It's an
On
index
prayer
attorney.
made on behalf of the IOC. Matter is returned to be listed after
My lord, 2 weeks.
2 weeks to enable obtaining a instruction. Yes. Is there any interim order?
No, my. Only notice. Obliged.
Yes.
My lord, item number 28.
2-8, yes.
You will please to adjourn the matter for today as my here is having. They have obtained the
Who is
consent.
the senior Roy?
Yeah.
Yes.
My lord, others, I have no objection, but they have earlier paid for filing affidavit, my lord. Whether they have renewed the prayer or abandoned the prayer, that's my aim.
Have you filed the affidavit?
Not filed, my lord.
Not filed. We grant you 2 weeks time. File the affidavit. You for the LICI, madam?
Yeah, for
The
respondent
private
number
respondent, 7 and 8.
What about LICI? Have they filed the affidavit?
Affidavit they have filed, my lord.
Whereas the respondent number 1, LICI, has filed the affidavit in opposition, such affidavit in opposition has not been filed by the respondent number 7. List after 2 weeks to enable filing of such affidavit.
May I please, my lord? I'd like to mention item number 23 and with the consent of the petitioner.
22 and 23.
23 and 24, my lord.
23, 24, yes.
Matter may adjourn for today as the conducting council pay and customization personal.
Taking the consent.
Right.
When do you want?
After 2 weeks.
2 weeks?
My lord.
on the prayer made on behalf of the Forest Department, matter is adjourned to listed of two weeks. Common order.
Interim may be contested.
Interim order passed at it continue with the next year of. Come on,
I beg to mention for withdrawal of a case.
When?
Any day.
Tuesday.
May it please the Lord.
Yeah.
But in this case, my lord, demand come so cause notice was issued, my lord, alleging that,
You have done the correction,
my lord,
the pages which were to be inserted.
my
you have-
lord, my,
Yes. What is the,
alleging that, my lord, we have evaded, my lord, tax, my lord. And thereafter, my lord, in response to the state notice, my lord, we have filed a reply. That is page, my lord, 52. Here, my lord, we have categorically stated, my lord, the income accrued out of the, my lord, in the, during the year 2016 and 17, my lord, out of which, my lord, most of the, my lord, received were from the government authorities, and those were exempted by the notification, my lord, dated, my lord,
but the order is of 2022.
my lord. We have, yes, my lord. There
Have
is,
you made any payment till now?
no, my lord. My lord, there is some delay on our part, my lord, because, my lord, my wife is, my lord, suffering from cancer, and I am, my lord, residing at Delhi.
So we have to issue notice then. What do you do?
My
You're a
lord, I am,
contract-
I
you're a
am contractor,
contractor.
my lord.
Or you last done it count for the who is active by by an order in original dated 25/11/2020 passed by Principal Commissioner TCS, Dibrugarh, whereby the demand of service tax and cess amount rupees 2,27,27,90 less that has been confirmed. The aforesaid amount pertains to financial year 2016-17. It is the case of the petitioner that such confirmation has been done without, but by ignoring the notifications dated 26/2012, which hold, which according to the petitioner holds the field that notice be issued returnable by foot. Yes, your name?
B. Sharma,
B. Sharma. For
for GST government on behalf of STCAL.
Sri B. Sharma, Learned Counsel, appearing on instruction of STCAL, Learned Standing Counsel, TCS, accept notice on behalf of all the respondents.
Sure.
That extra copy by, yeah, can you serve by date
My lord,
within 3 days?
my lord, notice may also go in interim time.
Your delay 1 year.
My lord, so my lord, notice may go, my lord, interim time.
The Learned Counsel prays for issuance of notice. Now prays for an interim order. However, considering that the impugned order is it has been passed almost a year back, that notice is issued on the prayer for it.
Trustee, on the last occasion, instructions were sought for Lord.
We have received the instruction.
Yes,
Land compensation has been divided equally between them. This is the two houses standing.
hearing was took place and on the basis of the Gampur report, it is held that that house is the name of the private estate law. So,
You have got your share,
No,
and if
Lordship,
you have a dispute with regard to the apportionment, there is provision in the act.
Lordship, regarding the report of Gampura, Lordship, kindly peruse page 45, Lordship.
4-5.
45, Lordship.
Yes.
This is the letter given by the Gaon Pradhan and other people of the aforesaid locality, Lordship.
Mm.
A public, can I go through it, Lordship?
Yes.
To the Additional Deputy Commissioner, Competent Authority Officer, Vishwanath, subject a public petition with regard to the co-ownership of Sri Lakshadweep Soikia and Sri Timber Soikia, both over the house standing on the land acquired for 4-lane national highway. Sir, in connection with the above subject, we have to honor to state that the two houses stood on the land measuring 1 kata 10 lessa covered by tag number 579 under Miadi Patta number 8 of village Hukazan under Brahmajan Mouza of Helem Revenue Circle in the district of Vishwanath. So far as we have seen since earlier, both the brothers constructed the house by spending money equally. That the local people have issued this certificate, signed this application after careful consideration of the matter. We make a prayer for dividing the amount of compensation sanctioned in the third phase between the Pattadar Shri Lakshadweep Soikia and the Pattadar Shri Dimba Soikia. This mass is our humble prayer. Lordship, this is the Gaon Pradhan.
Lordship, hearing was took place on 410. It is given on 610. After conclusion of the hearing, this
See, Mr. Bodlo, if you are aggrieved, Lordship, you cannot come up with this court. It's a matter of adjudication of the respective
Lordship.
shares. Which is the authority under the act? Which is the act applicable? in this?
Lordship, the National Highways Act, Lordship.
National Highways Act.
No.
I don't think the National Highways Act. Acquisition is under which act?
right to fair compensation.
Right.
So ADC probably.
Do you have any document of the acquisition proceedings, Mr. Butler?
No, Lordship, but the letter is annexed at page 34, Lordship.
Which act?
Page 34, Lordship.
Acquisition is under which act?
This is fair compensation act.
Or Lordship may issue a direction to dispose of my representation according.
That will not give you any. He is not the authority. Not get a- Before it's a provision for reference.
Yes.
He is more, he is not on the award, he is more on the apportionment. Yes, where is,
National Highways Act.
it is a part of the national highway.
But,
It is a part of the national highway.
Four-lane, Lordship, National Highway.
but it was done by the fair compensation act. Also.
How do you have any papers?
Some papers are there. Lord.
Just your instruction. Normally, the acquisitions are done under National Highways Act. So from where do submit the 13 Act? Any instructions? They are
No,
not-
no.
The acquisition is under which act? We just want to have the that information. If it doesn't say any check, there is an adjudicating authority. If it's a national highway, then normally the National Highway Act will be applicable.
Three H, four will come into play.
That's
I think.
it. But you have
Three-
also not stated any or annexed any document. It may not be the 13 Fair Competition Act. That act, the National Highways Act is basically for this purpose. To take
Three-
instructions, we'll issue a notice.
Look,
But
look.
this matter, we don't like to keep it pending.
Look,
If a short notice, I will after 2 weeks,
Look.
dispose this.
Look.
Did not get anything by having pending.
Look.
Third, PP Portland Land Council for petitioner. The petitioner claims to be a co-partaker of a plot of land measuring 0.040 hectares under dark number 579 of periodic patta number 8 of HUKAJN, Bukadan, Gaon, Brahmajan Musa, under the Helem Revenue Circle in the district of Vishwanath. The petitioner is aggrieved by the fact that no compensation has been assessed, the same has been done in the name of the respondent who is his brother. Sarah? In pursuant to the order dated 17/11/2020, 3, and Gustam with the London State Council has obtained certain instructions as per which a hearing was held on
410.
4/10/2020 on the matter, and he accordingly submit that the grievance of the petitioner has been taken care of. So, prepare with it me, no. However, it is not clear as to on which act the acquisition has been. But let notice the issue returnable on 6th of December. From the 6th of December, the and Gustam State Council accept notice on behalf
2, 3, and 4.
T.R. Mohanta, Planning Council, Revenue Department 1, and Gustam State Council 2, 3, and extra copies by 3 in 3 days. Steps for service of on this 1 of 5 be taken by Richard. On the returnable date, an endeavor would be made to dispose of it.
Oblige.
No. You take this back. Yes.
My lord,
and
my learned
anything
friend was supposed to take the instruction.
No, after your interim order is stopped.
Yeah, it is. My lord, my learned friend the other day was referring to that clause. But that is for repair. To the extent of the soil, it can be taken. And to the extent.
Meramot, we have seen.
Meramot.
Yes, any instruction?
My lord, the compensation amount in respect of the land required for periodic patta land that has already been determined, and compensation amount has already been determined. And for outright purchase of the my lord land which is required, my lord, petitioners will also be invited within that 7 weeks.
See, there are two aspects. First, to determine the compensation, he is
Yes.
questioning your competence.
My lord.
Whether you have
No, my
procedure.
lord, first we will offer it, my lord, as has done by the Asmala project.
So far as direct purchase is concerned, this court does not have anything
My lord,
at this
my lord.
stage. It's up to the parties.
Party.
Certainly.
If
And
the
perhaps they will also not be averse to the idea of having a direct purchase provided they are
In fact, we represented, my lord, these are on record. We said, you follow the due process of law, acquire our land for public interest, you are bound to give
And,
it.
I don't think if you have a reasonable offer
My
to
lord,
them,
we will
they
offer,
will
my
refuse.
lord. So, my lord, my instruction is that we have already determined what is the amount we will propose to them, my lord. they will, my lord, if they are not accepting our amount, my lord, then we'll go, my lord, in accordance with that, my lord, procedure, my lord. So let it be listed, my lord, after 2 weeks, my lord, and they will be called,
Status quo as on today be
my lord,
maintained.
in respect of the petition.
We can
That's a very fair stand, my lord. That will not occur.
for the petition to submit that in terms of the order dated 21/7 further demolition act.
Petitioner lands were not demolished, land of the other side of the, my lord.
No, 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 it
Demolition-
was demolished. It was
demolition activities.
My lord, I am having the video, my lord.
Demolition activity which was carried out, which was initiated, has been called. Has been the is to be a standing council. It is, however, submit that in the meantime, an assessment of the valuation of the land of the property in question has been made,
Determined.
which would be offered to the petitioner, including to explore the option of a direct purchase,
And petitioner will be
The,
invited within 7 days.
for which to bring the process to a logical conclusion from the learned standing council based for 2 weeks time.
Right.
Three, Chaudhary, the learned standing council for the petitioners does not object to the state proposal, provided that the interim order be extended in the meantime. That
15 December, my lord.
is it was down.
15 December.
15, my lord, 1 second, huh?
It is a Friday.
Friday. Or
Could
13th,
it
my
be on
lord.
18th, my lord?
Yes, sir. Last week, my
Oh.
lord. 13th also, my lord.
My lord, that week, that matter might continue, my lord, from 5th it is fixed. Or let it be kept for 15, let us see, my lord,
Yes,
in case
even
of
if
some.
you are not there, we,
Well,
on 15th of there are interim order passed earlier to continue the nature of.
my lord, on last occasion, we made a wrong submission that NH not 29, it should be 329.
The name of the.
Yes, it was not 29, 320.
Sri Chaudhary further submit that on the last occasion, the number of the NH was stated to be 29, which should be 329. Full stop. It is accordingly made clear that NH 29 occurring in the order dated 21/11/2023 should be read as NH 320.
Deep level.
Mr. Sahu,
Hello.
connected matter.
This is a subsidy matter, as a non-payment of subsidy by the T board. After proper inspection conducted
Who is
by
for the Union of India? CGC. Any CGC? Yes, madam. Have you been served or not?
T board, formed of Union of India, Minister of Industry.
I am for formal party.
Government party.
1 minute.
Who are the parties?
T board,
Development.
Union of India, Secretary to the Industry and
I
Commerce
am for
Department,
one.
and T board Director, Chairman T board, and Assistant Director
This will be considered by the T board.
T board. This is a scheme is approved by the Union of India, Minister of Industry and Commerce.
What about the Deputy Director of Tea Development?
They have-
Notice
We have a filed application as per
Or-
the inspection.
the Tea Staff Learned Council for the petition, who is aggrieved by the action of the respondent authority in not granting the subsidies which the petitioners, which according to the petitioners are entitled by them. The Senate Council has referred to the scheme, namely tea development and promotion scheme for medium term framework issued by the minister. that notice be issued, returnable by 6 weeks. MS S. Barua, Learned accept notice on behalf of respondent 1, that extra copy of the decision served upon her within 3 days. That step to take for service of notice on the respondent 2, 3, 4, 5, and 6 by itself proceed. Step to 3 days. Same order in the other,
Yes, yes,
and the scheme is the same
yes, sir.
between item number 4 and 9. And
Okay.
respondent pattern is the same.
Yes.
Yes, Mr. Bora.
May I please allow? And the petitioner for lordship, they are in residing since 2000 in wetland, my lord, in Tilsaku, my lord. And they are constantly they giving the regular taxing claims. My lord, just without due procedure of law, my lord, they was evicted on 13/5/2022, my lord. Now, my lord, government is going to, government have selectively some persons given some compensation. If one could permit me, my lord, page 100, my
You
lord.
said that you have been deprived of the compensation.
My lord, government rehabilitation.
Won't this require an factual determination, whether you were evicted, whether you were affected?
Yes, my lord.
Can we go into that?
Because of that, my lord, they are selectively, some persons are given
No,
compensation.
that is
but-
your allegation, that
but-
there is discrimination in giving the compensation.
Yes, my lord.
But to determine whether you are entitled to,
That will be decided by, that will be considered by the authority, my lord. That
Yes,
notice,
we
notice may
issue a
go,
short notice.
notice may go, my lord.
Yes, issue a short notice.
Like as regard compensation, has he approached any of the authorities?
Yes.
Where?
My lord. Page 88, my lord. So many applications are there, my lord. Page 88.
It is a settlement
Evicted
application, not,
family
not
in
for
Tilsaku.
compensation.
My lord.
It
Yes,
is
my lord.
settlement.
Nothing to do with.
The necessary step to consider evicted family, my lord. They are given directly, my lord. They then, my lord. In
Huh?
2022, my lord.
Where? Page
Page 88,
88.
my lord. So many applications
88
are.
to the Chief Minister.
Yes, my lord. I've evicted family.
He will give you compensation.
No, my lord. Actually, my lord, at the moment, my lord. So,
So where is the proper application? Mr. Barua is correct to the authorities.
my lord, the notice may go. In the meantime, I filed an application that may be by additional application.
You have not been approached the authorities.
My lord, because of that, my lord, they are evicted, my lord, all our photographs is
Evicted,
also
but
there.
you should approach the appropriate authority.
My lord, our, before eviction, my lord,
You should one document which was filed for the appropriate authority.
my lord, before my settlement, before eviction, my lord, I filed a settlement for the land, my lord.
See, that is not subject matter,
My
Mr.
lord.
Bora.
My lord.
Settlement is not subject matter at all. You are evicted. You have
Only the
accepted. Now your advance that in the step taken for grant of compensation, you are left out.
My lord.
Where is your claim?
Now, my lord, they are doing it, my lord.
You file an additional
So
affidavit.
file an additional affidavit, my lord. In the meantime,
Third
my lord,
and
notice may
Bora.
be go, my lord.
Senate Council for the petitioner
My lord.
who submits or who is aggrieved that there is discrimination in payment of compensation
My lord.
to the affected parties
Right.
who were evicted from the Tilsaku area.
My lord.
To the
Page 100, my lord.
to the action of eviction is not the subject matter of challenge. And in fact, challenge made to such action was unsuccessful. This, the S. Barua, State Council has pointed out that there is no material on record to show that any demand of the claim for compensation has been made. The documents which has been annexed do not appear that those were submitted for the appropriate authority. So that Sri Bora, Council for the petition,
Right.
grace for and is granted 2 weeks time to file additional affidavit
My
to put on record
my
the representation submitted for the appropriate
Right.
in this regard.
Right.
Please
Right.
for motion after 2 weeks along with additional affidavit.
my lord. My lord.
Lordship, this matter pertains to Lordship non-release of compensation amount, Lordship pertaining to land acquisition. Lordship,
Has been assessed or not?
Lordship assessment is done, Lordship.
But it has not been released.
No, Lordship.
Who are the
50%,
respondents?
Lordship, PWD, Lordship.
No. Who has taken over then?
Lordship, it is Lordship taken under Assam Mala program, Lordship, for upgradation of state highways, Lordship.
Where is
On Lordship 1711.
where is the document that compensation has been assessed?
Lordship, that is Lordship, page 24, Lordship.
24.
Lordship.
Yeah.
It is Lordship award statement, Lordship.
HP Nepal.
Lordship.
That it counts for petition. If you count the petition is with regard non-release of the compensation of the balance
Lordship.
balance
Due.
compensation for acquisition of the land in connection with the Assam Mala program for upgradation of state highway. Submitted that on 30/11/2020, so 50% of assessed amount has been released, the balance amount has not been released. So that notice be returnable by 4 weeks. This will be appearing. PWD Sri Mosam Bhuyan, Senate Council, accepts notice on behalf of question number 1, semicolon, PR Mohan, semicolon, for question number 2, semicolon, as Purva State Council. 3 and 4. That extra copy.
Of like.
May I please, Your Lordship? My Lord, this application is paying for, my Lord, the direction to the authority, my Lord, to consider my application for the demarcation and conversion of the prayer from annual patta land to periodic patta, my Lord.
Demarcation will come under the Public Services Act 2012.
My Lord. That, my Lord, I have my specific prayer was, my Lord, as annexure 4 and 5, my Lord. Page, my Lord, 24, 25.
Yeah.
That prayer is, my Lord, for conversion of the patta, annual patta to periodic patta, my Lord. That prayer is still pending, my Lord. So have not been, we have, the petitioner was pursuing the matter with the
Cannot direct for conversion of them.
And there is a policy, my Lord, government policy also there, my Lord, and Lordship
Policy
will-
doesn't mean that everyone is entitled to
Yes,
have
yes, my Lord, that they are required to inquire and consider the matter.
And what
my Lord.
about your prayer for demarcation that comes under the Act of 2012? Mr. Barua? What about the application here which came was filed for conversion of the annual patta, periodic patta?
For that matter, that notification should take.
Even
Page
for
20.
conversion?
Yes. No,
Page?
here on, if your lordship goes to page 28,
38.
28,
28.
and it's 7.
Yes.
On receipt, point number 3,
Hmm.
procedural step. On receipt of application, Lord Mondo physically verifies the scheduled land for confirmation of possession of the land, takes to the geo tag photograph of the scheduled land. These are the procedures. And then if we go down below 7, if the applicant
We can do one thing. Since procedure has been prescribed and he has filed an application, we issue a short notice.
Yes.
You have the inspection whether it was considered, rejected, or accepted.
That is
or else we can come up with the inspection on the day.
That's also we can have it on next Friday. They took hard Yes, sir, for the counsel for the petition. The petitioner claims that he is in possession of a plot of land holding an annual patta being annual patta number 114 of Katimari Kothar under Kasamari, Musa district of Nagaon.
My lord.
Though he had submitted an application in the year 2015 for conversion of the patta from conversion from annual patta to Miadi patta. No action has been taken to his information. The Learned Council has also referred on notification dated 11/11/2026, as per which the procedural step have been laid down. As per all other chief council, that for some time grant to enable to obtain based upon entire may also
Can it be on fourth?
this proposal has that to facilitate that extra of the upon him during the course of
All right.
May I plead your lordship, all the respondents are my lord Satyan holders of this tag number 107, 105 and 106 and 103, my lord. Thereafter, my lord, now respondent number 4 and 5 started a mini college stadium, my lord, in the about the plot of this land, my lord. Thereafter, petitioners filed a representation to the respondent number 4, my lord, page 32, my lord.
Yes. Why did you contest the earlier petition 3031?
My lord,
The affidavit has been filed there. They have disclosed their intent. You contest
in
it
this
by the
petition-
rejoinder affidavit.
my lord.
What is your first cause of action?
Now, cause of action, my lord, now this, my lord, challenges this allotment orders, my lord.
Where are the allotment orders?
My lord, earlier petition I have not challenging, not prayer is made by this to the petition.
Now, where are the allotment orders which you are challenging? Where? Which page? Madam, you need to file rejoinder in there.
They could have
Read
preferred an
petition.
IA in that case.
Or no, not a rejoinder, or you can also amend the prayer.
Due cause of
But the allotment order, where are the allotment orders which you are challenging?
My lord, additional deputy commissioners, my lord, 13/7, my lord.
Page,
2018.
41.
You cannot challenge an affidavit.
My lord,
You can counter the or refuse
Page 41.
the pleading by way of filing rejoinder affidavit. Where are the allotment orders? File rejoinder like this. Madam, do you think that the process is so easy to file a writ petition?
My lord, page 27, my lord.
27, yes. What is this?
My lord,
There is an RTI application.
This Pita copy, where is the allotment order?
my lord, madam, maybe page next week, my lord.
Obtain the documents, then you file.
In
Can
fact,
you rush like this?
In fact, in the previous rate petitions, clear stand has been given from the government side. If your lordship goes on to page 42 and 43.
No, we will not preclude her or the petitioner from challenging the allotment. But you have to do in the process which is recognized by law, not by the annexing the Chita copy that there is reference that the matter has that it can have been allotted. Challenge the allotment.
Next week, needed.
We granted 2 weeks time, try to obtain the allotment order.
But that allotment order is not part of the record of this.
No, they have to, they're granting time to obtain those. Read those on record. On the prayer of MSL Ojida, learned counsel for the petitioner, matter is adjourned by 2 weeks to enable the petitioner to procure the allotment order and place the same on record by way of additional.
Pleasure.
May it please your lord.
Yes.
My lord, page 23 is the order impugned.
Yes, what is that?
But this is an office order issued by the authorities of the college, the principal in charge, that is, placing the petitioner under compulsory leave for allegations which are there in the office order. Now, basically, my lord, my challenge to this is because there is no such provision of compulsory leave under the Assam Services Discipline and Appeal Rules 1954. At best, there could have been a suspension in contemplation of a disciplinary action.
Let us read that 20.
Page number 23.
Your name is Lokeshwar.
Yes, Laheshwar.
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 Is meaning suspension actually.
This implication could have been, my lord, suspension. But if it is to be suspension, even for suspension, the procedures which are required to be followed under the Assam Services Discipline and Service Rules as per Rule 6, that has not been followed.
Why?
Because the service condition, when a suspension order is issued generally, my lord, subject to correction in my humble contention, the service conditions of the delinquent employee has to be mentioned, stating thereby that he is placed under suspension from such and such date in contemplation of a departmental inquiry, and he would be placed under subsistence allowance from such and such period. Here, this order is so vague, so superfluous. Here,
we may not accept it.
It
may not be worded in the manner which is required to be, but everything is there.
And that
you are on compulsory leave. Let us assume that this should have been suspended on 7th of November till the departmental action is taken against, and there is also indication of the charge, allegation of molestation of
but my lord, here there are
Barwa, you have provisions in the act how to go about like this.
Yes.
Instructions.
But in any view of the matter, I don't think this is bench 5. Bench 3 matter.
Doesn't matter. These are all matters of convenience, division of benches.
But in
and my lord,
procedure has been aptly adopted in this case. But he is only upon the compulsory.
We need to notice at this stage. Also advise your authority.
Yes. The word
little bit of advice to cure all these kind of fiction or whatever. Ease of decrease. This is, substantially, we don't think we can do it.
Yes.
Nonetheless, when you have come 7th of November,
very promptly, immediately he has come because hardly any time has been spent.
Third, the Chakraborty done it now. The petitioner is serving as a bearer in the Government School of Art and Craft, Guwahati, and is aggrieved by an officer dated 10/11/2020, issued by the principal in charge of by the state office order. The petitioner has placed under compulsory leave with effect from 7/11/2020. Footnote. Para. It is the condition of the petitioner that no such provision exists in the service rules of 1994, and therefore the impugned action is not independent of. The as Barua, the State Council, on the other hand, contends that though the terminology used of compulsory leave may not be appropriate for all practical purposes, the same amount and order of suspension, and there is also an indication of the charges in the petition, which is grave in nature. But reader may complete note to written in court. Barua, State Council, on behalf of all the respondents. All the
Yes, yes, the third is the principal.
not by any. All the that extra copies by
two minor corrections. First is now it is not government school anymore, it is government college. So it was dictated as school, so it will be college. And the impugned decision is on 6/11, not 10/11. 10/11 is my representation. So page 23, 6/11. Page 23. Six. My lord, can a notice on my interim prayer be also issued? Only a notice, my lord.
It was served upon you on 10/11.
Yes. Obliged.
May please. If a matter relates to transportation of coal, Lordship.
Transportation of coal.
Coal. Impugned order is at page 28, Lordship. Similar matters are pending, Lordship. Interim order has already been granted, Lordship. 31 and 34 are the relevant pages of respective orders. Page 7, paragraph 7 of page 31.
You were directed to have no objection certificate from the respondent number 3.
Yes.
That is the subject matter of yes.
The business farmers ration 27/4/2023 my lord, Nectar 1 my lord. And it is of my 10 to 2/22 my lord. After 1 and 8 months, years. Annexure 1 my tell list my lord. Is trade license of my lord 27/4/2023. And impugned order is of my lord 10 to.
And the orders which you are referring are also of the year 2022.
Yes, fellow. One is 11/3/2022.
Lordship, may come to below columns, Lordship. The year 21, Lordship, valid up to 22. Year 22, 23, valid up to 23. And next 23, 24. Lordship, valid up to 24. The valid license that has been issued by the authority, it's a renewal copy.
But that's otherwise it.
Yes.
Third, for the petitioner who has to challenge a communication dated 10/2/2022 issued by the respondent number 3, whereby it is provided that before being of rail rake RAK for transportation of coal, the transit pass submitted be sent for verification and issuance of no objection certificate jointly by the responsible and the Directorate of Geology and Mining Assam. Is submitted that similar matters are pending in which impunity has also been paid. P.S. Pothak, DGC,
No, I'm appearing from the above.
for whom?
One and two, madam.
For the railways.
Yes, madam.
P.S. Pothak, representing the railways, however, submit that the approach of the station is delayed as the order impute is of February 2022. For the that notice written by 4 weeks with water. Current council accepts notice. We have on it. 3 years, state council 3.
Yeah.
MSS for state council accepts notice. They have responsibility and stock of parent with regard therefore it is not put in the opinion. Opinion that the communication that the impugn that the demands being against the company which is general in nature and is already been and has already been paid in other proceedings from the same stay order would also cover the present case. To make it explicit from the returnability of it is direct that a communication is 10 to 2020 issued by the managing director Assam Mineral Development Corporation Limited shall remain suspended.
That's it. Name of the ZA may be reflected in the court.
All this to reflect the name of PSM.
Public.
This matter, my lord, the lordships have earlier dealt with this matter and similar matter, my lord. Page 70, this is regarding the 2% royalty which is being sought by the urban local bodies, my lord. That was challenged.
Private construction.
Yes, and private construction. I am building a school, my lord, and my NOC is also being held up because of that non-payment.
It does. Hard. Take on to the council for the petition. The petitioner is aggrieved by the demand of 2% royalty by the forest department. By contending that such demand is not acceptable for construction done for private purpose. It is also submitted that similar matters in common interim orders have been passed. That notice is returnable by Sri Kanpur is the learned counsel for the petitioner submit that the construction in question by the petition is for the purpose of opening a school. And the petitioner itself is a charitable trust. This notice is issued returnable by 4 weeks. And yes, thus, council accept notice on behalf of 1,
1, 2, 3.
1, 2, 3. What about 4, 5, 4 and 7 as to here? 5 and 6?
I am for 5.
As for 5 and 6. Extra copy. Yes. Correct. Or the council on the interim therefore pending. No. After hearing. Directed that with the returnable date, comma. The authority could not insist upon the payment of royalty while considering the grant of building permit.
So let the matter be tagged with the original writ petition, my lord.
Yes.
204023.
Building permission, which however is required done by following the other requirements of law. Please tell me every 2040.
Stipulate.
You serve extra copies.
Please, your lordship.
Yes.
Expiration method.
Yes.
Expiration method.
What's the question?
This is your lordship regarding motor vehicle.
Have we asked you?
Sorry. Sorry.
Please reply when we ask something.
Yes, I'm very sorry.
Yes, what is the question? To come, stand and say, ex gratia, matter is over.
No.
Is it that easy? What is ex gratia? What has happened?
Expiration. Motor vehicle.
Huh? What motor vehicle? What has happened? Tell us the facts at this.
This after
Why after some time? Was this the first item? We take it after 5 minutes. Come prepared.
Yes.
You tell us, explain what is ex gratia. Yes.
May I appeal? My lord, we have telling people at impugn notice and the resolution that your lordship will find at page 25, my lord. Page 25.
25.
25.
Yes.
My lord, his membership has been cancelled from the my lord Gusaigaon Bar Association, and my lord, he has been restrained from practicing of law in the said court of law.
This is by the Bar Association.
Bar Association, yes. Now, once my lord,
Read lie against the Bar Association.
now lordship will consider, my lord, once my lord, enrollment is my lord holding the field, nobody can stop him to practice of law.
Enrollment is by the council.
Yes, work council, yes.
This action is by the Bar Association.
Bar Association, fine, my
Will
lord.
it have any enforcement by law?
Now, practice of law, my lord, in the code, my lord, code of law, can there, my lord, anybody
Sir, can you
stop?
come to a writ court against an action of an association? This
No.
is a private dispute. We are not saying that you may not be aggrieved. You can very well be aggrieved. But approach the appropriate forum.
But he's restrained from my lord, practicing in the code of law also by the said Bar Association, my lord.
Approach the police, approach the civil court. Your license is by some other authority,
Yes.
by the council.
Now,
Who is the Bar Association to stop
Yes,
you
my
from
lord.
practicing?
once my
They may
license,
stop you from using their facilities,
yes,
but not in the court.
yes, we cannot,
Court does not belong to the association.
yes.
But how is the writ petition maintained?
Now, once he has been restrained from practicing in the code of law, my lord, ultimately his livelihood is not hampered.
That is stretching too much. In a civil court, this aspect cannot be taken into
Yes,
consideration.
can be, can be,
Yeah.
can be.
How do you pass an order against an association?
Now, lordship kindly see, my lord, action has been taken without any notice, any show cause, any opportunity of hearing.
Understood. You have all the case.
Yes.
Everything is there in your favor on merit, but on the maintainability of a writ petition.
Now, my lord, Article 19 directly, my lord, hit here. My lord, once the bar license is, my lord, holding the field, nobody can, my lord, stop me in practicing the
Have you
code of law.
approached the police?
My lord,
Have you approached the police authorities that you have been obstructed?
no, my lord, he has approached the, my lord, bar association itself, praying for, my lord, my lord, resolution adopted against him. That was not also punished. Lordship kindly see page 30.
it's an internal matter. Bar council can remove you from this.
That is fine, but
Depends was- What did you do?
Hit by 19.
What did you do?
But he's an advocate.
No, what have you done to?
Now there is a case against him. In that case, he has been granted bail by this honorable court.
Case, what is the allegation?
Allegation is regarding case was registered under section 376 and section 6 of the POCTO Act also. He was granted bail immediately.
You are a man with high reputation.
Because of some conspiracy of the particular
No, we have not said anything. Have we said anything? That you are man with high reputation. Allegations are serious. The entire
is the victim of some conspiracy made by somebody.
You may be correct, maybe a conspiracy, but you not enter. He approached the civil authority.
Now, once Article 19 is he, Lordship can protect.
The provisions of the Constitution are not applicable in a civil court. Is it only applicable to a writ proceeding under 226?
Yes, that's fine.
It's a fundamental right. Anywhere you can enforce it. But to come against a bar association, writ proceeding, is permissible.
Now it is directly hit by Article 19.
You file a suit, pray for an injunction.
Now, once the fundamental right is interpreted by.
In all matters, you can stretch that fundamental rights are being valid. Even in a rent control matter, you are supposed to be outside from your house. A tenant, you can say my right to living is being affected. Please protect me.
Yes.
Can we do anything?
Yes, that is
Why?
there,
Why
that
did
is there.
Why do you make a distinction?
Now here, Article 19 is directly hit by the some agencies. They cannot. The bar association is the recognized by.
Have you approached the authorities?
Yes, we have approached the authority.
Which authority?
They have not the bar
Which
association
authority?
itself.
The bar association is not the authority. You approach the authority. That is
At best, he could have gone to the bar council.
file an application to bar council. File an application for the
Maybe the police.
registrar of the before the authorities, registry of the court. Where are your statements that you have been obstructed in attending the court proceedings?
Yes. We have narrated, my lord.
Where?
My lord, Lordship kindly see page 8 per 8.
Yes, please.
My lord, that the petitioner expressed that no person can be restrained from practicing from advocate in a court of law so long his enrollment as an advocate is holding the field. But the given case, the petitioner has been restrained from practicing by respondent number 3 and 4 in the court of law by the Gosaigaon Bar Association, which is in gross violation of the.
Have you made the bar council a party?
Bar council, my lord, is not party, my lord.
Right.
Because my lord, there is no, my lord, case against the bar council.
So license is by the bar council.
Yes.
Make the bar council party, then we think of things.
My lord.
Third, PMB Montal Council of Petition, who is aggrieved by a notice dated 28/7/2020 issued by the President, Gosaigaon Bar Station, whereby the petitioner, who is an advocate, and this cancellation of membership, how can we look into?
No,
this notice it cannot be a cannot be a matter of adjudication. We can at best adjudicate it the matter of restraining you from entering.
Yes, sir, that.
So the aggrieved advocate has been restrained from practicing in the court at Gosaigaon. The Learned Council has also referred to a notice dated 28/7/2020 issued by the concerned bar association, whereby his membership has been cancelled. As Barua, the State Council, however, raises the preliminary objection on the maintainability of the and submits that cancellation of a membership of an association cannot be the subject matter of dispute in a litigation. Three, Mondal, the learned counsel for the petitioner, however, submits that the aspect of restraining him from practicing in the court is still there, which is required to be looked into. That, uh, this court has, however, noticed that appropriate application for concerned authority have not been made regard, and the concerned bar council has also not been made a part. The Mondal Senate Council for the petitioner based content to file appropriate application for treatment of part. The question of mention how is open and it's considered on the
And his name also deleted from the advocates. Vokalatnama.
Vokalatnama is by the bar.
Yes. And private Vokalatnama also they have restrained to use by the petitioner.
Vokalatnama is not accepted by the by the court. How can it be accepted by
Obliged.
Notice will go down, my lord. Only notice.
What is the matter about?
Matter is very serious, my lord, because the
Very serious.
very serious, involving the life itself of the family.
What has happened?
My lord, actually it was a political rivalry, my lord, belonging to different parties in Lamding. So, my lord, the person who is holding the chair of the membership of the assembly.
What kind of high-handedness, what kind of apprehension are you having?
Even being encountered, my lord, there is the what is given there are a series of applications. Even the government of India, Home Ministry is also, my lord, by Annexure 4, page 41, wrote to the government of Assam to take necessary action.
Where?
Page 41. Annexure 4.
Have you made the MLA a party?
Yes, I made.
Where is your approach to the authorities?
All approach, my lord, from government of India to government of Assam, even Chief Minister, there are OC, SP, DGP, there are series.
What did the Human Rights Commission do?
Human Rights Commission simply called for the report, my lord, and I went and met the member of the Human Rights Commission. My lord. The reply was the same police who is arresting, from them only report is called. So called it is not effective for you to expect anything from here.
Did police take action or
no?
No action.
Rather, 3 FIRs were serially filed.
You
Even
filed,
valuable case, my lord, I was detained in jail. Lockup.
Now, what about your FIR? Did you lodge any FIR?
Number of FIRs, my lord.
You have lodged?
Yes.
What action taken?
No action. To SP, then OC, then also SP.
You are a political activist.
Political activist.
You are a political activist.
In fact, I'm the member of president of the Lamding branch of the AGP, Assam Gan Parishad. Actually, the dispute was in 2021 when there was municipal election. So AGP also wanted to contest 2-3 seats out of 10. In that, the MLA lost his cool, my lord. Then started harassing me, and that fight is going on.
These are political rivalries. You belong to one political party.
Your lordship goes to the order passed by the Human Rights Commission.
Yes.
So it is very clearly reflected what
Yes.
exactly has happened. Page 45, Annexure
45.
6.
Yeah.
On the paragraph 2, para 2.
Yes.
From the perusal of the petition and annexure documents, this commission feels that the whole matter relates to some clashes between the petitioner and the local MLA. So and so. The commission do not like to pass any order at present, but by the petitioner.
Now,
He complains
what about the
Lamding is hereby
what about the report?
to the Lamding.
What about the report by the district magistrate?
Yes, that we can.
So we issue notice,
Yes, notice.
but do not want to preempt something which is being within the jurisdiction of the Human Rights Commission. You have approached them, it's not been rejected.
Not rejected.
What happened on 24/8?
Huh?
You come to page 45.
Yeah, 45 minutes.
The next day.
Yes.
Kindly come to the next date.
Then report was called from the OC.
What happened?
The report has not come yet.
But aren't we preempting?
Now simply notice may go, Mara. Let them reply.
Will it not amount to preempting the action of the? Will it not amount to preempting the Assam Human Rights Commission from acting?
No, because Human Rights Commission, the person, the petitioner directly went and made the member. Now there is single member only, because chairman is not yet appointed. So, Mali, the member told my lord that you, because since it is the dispute between, fight between the MLA and you, better you approach the other authority.
No, that is what you have made your oral submission. But
Yes.
on record, we find that maybe there are no, chairman is not there. But rightly or wrongly, the
Proceeding is pending.
honorable member has issued a notice, fixed the next date, called
Yes.
for a report.
Yes.
You said the report is also there. Aren't we required to wait for the commission to act? Simply now,
That's what, my lord. Now only notice may go. If the report comes, my lord, anyway, I'll produce it in the next day. I will again file.
we will not issue notice, we'll say something will keep this pending.
Yes.
Third, the RP sir, count for petition who has made serious allegation of high-handedness and harassment meted out to him at the instance of the respondent number 8, who is the local MP. The document close to writ petition, however, discloses that the petitioner has also approached the Assam Human Rights Commission, which had also registered a case and note, and reports were called for by the order dated 13/7/2020. Sri Sharma, the London Senior Counsel, however, apprehends that since the investigation be done with same police authority, there could be serious, there may not be a fair dispensation of justice. This court is, however, of the opinion that this matter is presently being into by Assam Human Rights Commission. It would not be prudent to on part of this to enter into subject matter of this on a final order to pass by the or the petitioner is aggrieved by any intermediate order. Therefore, in the interest of the this court is that interest of the could be served if it is kept pending and delisted. Now is the and listed after 4 weeks, by which time the petitioner would apprise this court of development.
May I get the liberty to serve the notice, my lord?
Notice, no.
We are not that you can do on your apprise the court of the development that may take place in the minute. We'll fix the date based on 5th of January.
What may it is? Please, Your Lordship. If the petitioner is aggrieved by the inaction on the part of the respondent authorities in not executing the order dated 21/10/21 and the eviction notice dated 7/12/2021 passed against the respondent number 6, Your Lordship. Lordship may kindly come to page 16, annexure 2, Your Lordship. That is the order passed by the competent authority.
Yes. Third,
Notice में ले लो.
PC Board by Learned Counsel for the petition. The petitioner had purchased a plot of land measuring 1 katta
Covered by the
covered by tag number 372 of patta number 200 in village Kapoha of Kapke Musa Janai in the district of Borbet. The approach of the respondent 6 to encroach the land of the petitioner was resisted by him and by lodging a complaint in which necessary orders were passed for removing the encroachment. On
21/10/21. 10/21.
10/21. However, the state order has not issued, as a result of which the petition is facing from immense consequences. That notice is returned by 4 weeks. MS as per order, state council accept no revenue for Madam and for any council revenue except one. 1 and
3
1,
above.
3,
3.
1, 3. As per for 2,
2, 4. 2 and 4.
4. PWD and also here for
3
5.
also I
Three. Also here for 5. Extra copy. 6 by 7. Right. Yes.
It is your lordship.
Yes.
First, this matter, there is a compensation.
What is the meaning of ex-gratia?
Grace.
Hmm?
Grace amount, right?
Grace amount. What grace amount? Yes, what has happened? Tell us what has happened. What are the facts?
Hello, come to page number.
Tell us what are the facts. You don't need to go to the pages. What happened?
The wife of the petitioner, Hasibon Begum.
Hmm. What happened to her?
So, like motor accident, my lord.
She died in a motor accident.
Yes,
When?
my lord. 8/12/2020.
Okay. Then what happened?
Then FIR lost, my lord. 14.
As far as the laws, what happened to the police case?
Police case, my lord. CPSR case number 544/2022.
What happened in the police case? Now, what do you want? This court. What is the relief? What's the relief you are paying for?
Ex-grace completed.
As Christian, as per what?
As per the notification.
Which notification?
15/11. 15/11.
1511.
Yes, my lord. Yes, my lord. 14.
Not court. What does it say?
Paragraph 3, my lord.
Yes.
Ex gratia to
the NOK of person killed due to accident in public place or in public crisis. My lord, sorry, my lord, carrier others than killed by extremist territory, extremist terrorist, miscreant, and due to the fighting of security forces.
Yes, what's your name?
Hekimullah.
Hekimullah.
Yes,
Or Hekimullah Learned Counsel for the petition. Who by means of petition is claiming tax pressure in respect of a notification dated 15/7/2015 of Sarah. The petitioner claims that his wife Ajibun Begum had met an accident death on 8/12/2015 for regarding which it was her case number 544 oblique 2020 under section 79 304 TI note and for 1 finance alright for 2 3 4 5 and 6 7 3 days extra 3 days.
Actually, also my lord, civil.
Yes.
May I please, my lord, the articles of my lord, tower, my lord, Reliance Tower, which was in possession of the petitioner, was taken away, my lord, illegally taken away by the respondents, my lord, from a particular from a 4, my lord, without giving any, my lord, notice or any, my lord, seizure list, and my lord, no case has been registered, my lord, in this case.
How are you connected with Reliance?
My lord, by an agreement that you kindly see, my lord, page 14, my lord, lease agreement.
You were holding a lease.
Yes, ma'am.
And these articles have been taken from you without any authority of law.
Yes, yes, ma'am.
Was there any court proceeding?
No, ma'am, nothing is there.
No civil case?
No, ma'am.
No
nothing.
direction of it?
No, ma'am.
Third, the R.S. Chauhan and found for petition. The case of the petition that there was a lease agreement dated 15/7/2007 between him and Reliance Communication Infrastructure Limited, in terms of which, certain articles like the diesel generator set, air conditioner, etc., were in the possession of the petitioner. The equivalence of the petitioner is taking away of those articles by the respondent of court without following the due process of Sarah that note returned by court as for all the respondents. Extra copies.
Yes.
My lord, this is regarding the execution, my lord, the husband of the petitioner died on, my lord, on 7/2022, my lord. Accordingly, FIR lost, my lord, at page 16.
date of 1/7. I had a
Well,
4. Yes, who will be
I am for pieces.
on MR Burua,
I am for
RM Burua. Therefore, revenue department on airport of 1 to RM Burua. Then Burua, SR Pro, S Burua for
3 to 7.
all right.
Lordship, petitioner aggrieved by the notice dated 28/10/2023. Lordship issued by the respondent number.
Are you holding a government post?
Lordship.
You have been transferred.
Lordship. I have transferred. Otherwise I have nothing, Lordship. Only humanitarian guard. He may be allowed to stay sometime.
When were you transferred?
Transferred, Lordship, 2022 at Hailakandi.
22 which month?
Lordship. I'm not sure. But
1 year you are occupying the
1 year.
quarter.
some more time.
Some more time.
Otherwise, Lordship, I am also not receiving any rental house rent.
Doesn't matter, but can you occupy a quarter at different place or not receiving house rent? Hilak is a different. Who is staying?
Health issues there.
Who is staying in this quarter?
His family member, his wife and his the daughter and his son. Lordship, we have filed a representation that may be considered by the authority. That
Heard the alarm of the Karnataka Council. Also heard MS as for State Council
For all respondents.
for all the respondents. Considering the subject matter dispute, this is taken up for disposal. As the motion is the petitioner is working as what? As a constable?
No, Lordship, as a clerk.
As a clerk under the commandant of the 21st AP IR Battalion, Air Protect, from a country in the district of Hailakandi. On subsequently, he has been transferred to the 5th Sonkila, 5th AP Battalion, Sonkila, Dima. Where are you present? Where are you present?
At present, at Kachichola. Present place of posting at Kat. Before that, he was at Timahaso. At first, he was at Silchar, and then, at that time, a quarter was allotted, and then he transferred to Dimahasaw, and then to Hailakandi. Then to Hailakandi.
Presently, you are at Hailakandi.
Hailakandi. Hailakandi, Katlichola.
Where are you occupying the quarter? Which place?
It is at Silchar, Lordship. Lordship, kindly have a look at Annexure 3, page 12.
Sir, enough is absolutely constituting.
Lordship, kindly have a look at page 12, Annexure 3. This is letter issued by the
Who was initially posted at Silchar and in connection with his employment, he was allotted a government quarter at the Ramakrishna Mission Road family quarter, Silchar. The petitioner was thereafter transferred from Kachar DEF to the 5th AP Battalion, Tontila, the district of Dimahasab, and further transferred the 21st APBN Katichara, the district of Hailakand. The petitioner is, however, aggrieved by the action of the respondents in directing him to vacate the quarter under his position as Silchar. Sri Madhukar, the counsel for the petition, has submitted that the petitioner is having certain difficulties for which the quarter as Silchar is under his occupation, where his family members are residing. As Barua to the State Council, however, submitted that the present there is not legally tenable in as much as a government employee does not have the right to continue position of a quarter allotted after he is transferred from the state place of that. A perusal of the documents annexed and the facts involved would disclose that from the place of post in the district of Kachar, the petitioner was transferred on 2 occasions, firstly to the district of Dimahasab and thereafter to the district of Hailakand. The Annexure 3 of the restriction also disclosed that the notice was the third and final notice. This court is of the opinion that there cannot be any indefeasible right of a government servant to continue occupation of position of a court allotted to him after he is transferred from the state place of post. Further, this case it also appears that the position of the quarter at Silchar has been done for more than a year after his transfer from Silchar. That view of the above, or the view that no case was preferred, and according to the report. However, consider the facts and circumstances, this court the view that the petitioner and further time up to up 8th of December 2020 to vacate
Lordship,
the quarter.
may I pray one thing? Maybe up to January, Lordship.
After the open occupied vacate the mic.
May I please, Your Lordship, the matter pertaining to non-payment of ex gratia relief. As my husband died in a road traffic accident I had made application before the Deputy Commissioner, Borpata district, but it is lying unattended till date.
Our data. Date of accident 14/1/2021. Husband of the petitioner, Gopal Das. What is the police case? You have not mentioned the police case.
Yes, sir. FIR is there. 20 on page number.
What number?
Side copy 20, page number.
Sarabadi case number 94 of 2021 under section 279/304 case. Correspondence code.
Respondents revenue department, finance department.
Revenue, fine code block 1, finance, RM code block 2,
DC,
3, 4, and 5 as extra copies printed.
Obliged.
May I please, Lord. I appear for the petition, my lord. This petition, my lord, under the provisions of the GST Act, Lord. Because I am a registered dealer, I am filing my returns, paying my tax. An audit has been conducted. There is a special provision for an audit, my lord. There is a special procedure also prescribed for an audit, my lord, by an officer authorized by the commissioner. He is an authorized officer to conduct the audit, my lord. He conducts an audit. He comes out with his preliminary findings, saying that please give your response to these preliminary findings. I file a response, my lords. Without considering the response, a final audit report has been issued on 27th of September. I file my reply, my lords. They issue a final audit report on 27th.
Now, from where are you developing your submission or made the submission that your response to the initial report of the audit was not?
Lordship, may kindly see page 85.
The final report 27/9.
Our final audit report is 27/9. Lordship, I file a reply on 29/9. Lordship, they don't even give me 2 days. They take 5 years to conduct audit.
Now, when was the preliminary notice given to you?
19/9. By the time Lordship, this is the data for 5 years. By the time I gather the data,
And the final report is after around how many days? 8 days.
8 days on 27. And be that as it may, Lordship, may kindly have page 85. I file a detailed reply at page 85 on 29. Lordship, this is the detailed reply, para by para.
And that the final report is already been.
They issue final audit report. Not only that, on next day, 30th, they issue notice also saying that no, we are not bothered. Kindly look at their notice, my lord. Kindly have a look at their
page.
At running page 68. That is exhibit A or annexure A, my lord. My apologies.
68.
Page 68. Can you look at the notice, my lord?
Yes.
Has my lord got that notice, my lord? Kindly see clause A, brief fact of the case as per annexure. Grounds as per annexure. And this is the computation. Now, my lords, over the page at page 70, kindly look at the annexure. Is this a show cause notice? Mere computation. What is the fact of the case? Where is the violation? Which section have I violated? Which rule have I violated? And why do you say I have violated and I have to pay this? Is this a show cause notice?
This is not the show cause notice. This is the demand.
Yes, that's it. This is it, my lords. The law requires them. I'll show your lordship section 73.
Now, where is the original, the first notice which was given to you on 99?
Lordships. That is at running page 73, my lords. Exhibit C, annexure C, my lords. Running page 73.
Sir, I don't think we may not too much impressed by your submission that the final order does not have the details. But since you have participated in the process,
Lordship.
reached 99, but you at the same time you had made a submission that very inadequate time was given to you
Lordship,
to
no
find your
submission
response.
is not, then what is
And-
the point of this audit?
And your submission in fact was, and before you had submitted the final, they have already taken the decision.
Yes, my lord, kindly see
Yes,
page
Mr.
74, kindly have page 74 just for 1 minute. Last line of their audit observation. The above objections are brought to the notice of the auditee, and if any further issues are noticed on the basis of the analysis data, same will form a part of the audit note. It is clarified this letter is not a nature of show cause notice, only participative fact-finding audit, under which preliminary and tentative audit are being shared with you to know their viewpoint. Then listen to my viewpoint. Then what is the point of doing this? Straight away issue show cause notice. Why are you doing this exercise? And because, my lord, this is the law provides for it. Not only that, before show cause is issued, my lords, the law provides that a pre-show cause should be issued.
68 is the demand notice. So what? 68 is 68.
It's the show cause notice. Lordship, may kindly see page
It's a
68.
summary of show cause notice.
Summary of show cause notice. 27, 30, Lordship, what is the urgency?
39.
27 final audit report, 30 show cause notice without considering my reply. What is the urgency? You may not like me, my lordship, that's a different matter, but what is the urgency?
39. When was, how much time was given to you? By this 39 notice?
39 notice said you file your reply by 3010.
Have you filed?
No, my lords. I'll just tell your lordships, my lord. I can file my reply, my lords. My lords, my submission is this, that if the audit had considered my submissions, no need for notice would have arisen. 1. 2. Kindly have rule 142, my lords.
No, Mr. Ramsar, whatever maybe the audit was a preliminary process.
Lordship.
For, they have not yet taken any final decision to pass to impose any penalty or make any demand.
No, show cause
they have solicited your views by issuing the show cause notice based on an audit, which you say that process is not in accordance with law because the audit report
Lordship.
was acted upon without taking your views. But that report, while being acted upon, is also at the stage of final consideration where a response are sought for.
No, that is
You
over.
file your
my lord.
response.
No, that is over. That's my submission. Kindly have 60, just see 2 sections, my lord.
Yes.
Kindly have 2 sections.
No, what about the notice, show cause notice at 39, 20, 26? You said this is a show cause notice.
This is a show cause notice, my lord.
You
This
file
is
your response.
show cause. My lord, I'll file my response, my lord. I have no difficulty. I'll file my response. Let them not adjudicate till your lordships decide whether the proceedings are bad in law or not. My submission is that. Kindly have 65.
Is it a condition precedent that such show cause notice has to be preceded by a audit report?
Yes. Yes.
But audit report says 7 days. You did not file your response within 7 days.
Lordships, let us assume for a minute, lordships, that I did not file my response in 7 days. There's an audit for 5 years from 17, 18 to 21. I took time for that. Let us assume, lordship, they issued an audit on 27/9. Let us go by that. Let us go by that. Kindly have page 71.
Yes.
Kindly have page 71. That is 27/9.
Correct.
Lordships. Kindly have page 85.
Yes.
That is 29 September within 1 day. Kindly have that.
85.
Page 85, 86, 87, 88, 89, 90.
Yes.
Is my detailed response. And kindly have page 90, my lords. Kindly have page 90. Basis the explanation and submissions made above, we do not agree with the findings of serial number 1 to 3 of the report. We request your good sir to consider the submissions made so. We reserve our right to add alter. We request you to give up opportunity of being heard before you finally conclude the matter. Then 30th notice. Then what is the meaning of this? It is redundant and it is contrary to law. I will demonstrate, my lords. Lordship, this is the reason why there is a requirement of an audit.
Chaudhary, what do you say?
Lordship, first of all, he is aggrieved by the issuance of the show cause notice. Basically, Lordship, that his reply has not been considered. Lordship, he is aggrieved. Then there is an appellate forum, Lordship. He ought to have gone over there if something has not been considered while issuing the show cause notice. That he has not. First point, Lordship, he has an alternative remedy.
Notice he has not even filed his response.
Yes, Lordship.
So, he is questioning the
basis of the
preceding action which has culminated in the show cause. Says that you ought to have done this, which you have not done, and it appears that previous action was a mechanical process.
Yes, Lordship.
And we were without considering that, you have straight away gone process of show cause. Now we were not very inclined to say the entire process of show cause. Let it find the response. Don't
Yes,
take final action. We'll examine the point which trying to raise.
Yes.
And we'll also examine the point of maintainability.
Yes. Yes. I don't know.
Third, the right hand and turn it count for petition who has challenged notice dated 39/2023 issued by the authority under the state GST. State GST.
Lordship.
Yes,
Lordship.
Under section 73 of the So-and-so Act. It is the case of petition that the conditions precedent have not been followed, and there is only a mechanical exercise by which notices were issued by the audit authorities, and without even considering the response filed by the petition, the so-called notice has been issued in hot haste, that too for period for the year 2017-18. Correct?
Lordship.
Sarah? The Chaudhary, standing on Finance Taxation Department.
For 4 and 5, Lordship.
However, submit that the repetition premature as no cause of action has arisen in as much as the petition is yet to file its response to the so-called notice impugned in this petition. The Raichanden Senate Council has, however, responded by submitting that the petitioner is not averse. The petitioner is willing to file the response to the so-called notice, which, however, is required to be made subject to the outcome of it. And any action, which, however, he further submits that further action cannot be taken by authority. That notice is returnable on. Tell us the date. Date of your
'Any date convenient to your Lordship.
15th of September, it's 30 or 10.
Friday. 15th is fine. 15th.
Union of India? Anybody? Madam, Union of India. MSS Guru, Senate. Please take the notice of the number 1, 2, 3. 1 and 3. Whereas each other Senate finance taxation, I think 2 also.
Lordship, it will be 2, 4, and 5.
2,
4, and 5.
And 5. So we could 1. Put together. That extra copies of the be served before the learned council for the respondent with 3 days. It is, however, made clear that the process initiated by so-called impugned so-called notice dated is not paid. However, not it, meaning there, but the petitioner is required by its response within the time stipulated for submit. However, observed that no final action is taken in the process initiated till the next turn.
Lordship, can it be on 18th, Lordship?
It's the last.
Yes,
Any Thursday or Friday, my lord, my apology.
15 Lordship, I will be out.
Monday and Tuesday we have.
5th of January,
Yes, ma'am.
Friday,
5th is fine. Right.
5th. Give extra copy.
Lordship will serve. Great. We are obliged. ma'am. Great.
Yes.
Lordship, here in the instance, your Lordship kindly peruse the last date, last order, my
Yes,
lord.
yes. Happily married.
Yes.
Yes.
The some instructions that I provide.
What is your status?
School
What is your instruction? I have. Sufficient evidence not found. It's under investigation.
Evidence, sufficient evidence not found, my lord. Whether statement of the girl has been recorded, my lord.
Yes, record. The accused were called to the Thana, their statements were recorded, they were examined.
Yes, my lord.
They are your relatives, your mother, father.
Mother is
I am not mother and father, my lord. One thing is the case has been registered under section, my lord. As your lordship said, my lord.
294, 323.
506. For the other boy, my lord, who want to marry that particular girl, there is a specific allegation of 354. If your lordship go to the evidence of the, you go to the section
That is
of.
a different aspect.
Yes, my lord.
But they have also stated that your allegation was to the extent of threatening to kill. That aspect has also been looked into. You file affidavit, but you grant protection. We are mainly on
Yes, sir.
epic case.
And following that, my lord, Delhi High Court also passed an order, my lord, of passing.
there is another case filed against the petitioner also, Lordship.
Against the petition. What case?
The fifth Lordship.
Theft.
Lord.
What have you stolen?
Yes, my lord.
You have stolen the daughter?
Yes, of course.
Second paragraph, Lord.
Who is Poljahan Nessa, your mother?
Yes, my
That's a the daughter ran away. Javed was kept for her to put it. While going away, you had also taken 30,000 rupees with you.
That is the law passing has said, my lord. I am reading law passing.
No, that's a different
Yes, sir, yes,
allegation.
sir. I have to know the case number also, my lord. I do not know the
Case number is there. Fall under the PS case MMR number 59 of 2020. You may have to take bail tomorrow.
No, my lord. Actually, in this case, I think, my lord, I was allowed to go on PR bond, my lord. It's okay. That's 59, 2000.
Why don't you sit and talk?
Yes.
We are ready, my lord. Only thing is that they should not, my lord, try to take me away from my husband, my lord. Petition number 1 person.
How can they take you? You are a major. It's a different matter that you are 14 years, you have made it
Yes,
24.
sir. Earlier they have taken to the shippers area. You also kindly go my
You are
FIR.
14, aren't you?
No, my lord.
You have made it 24.
Oh, yes, my lord. I have also checked one thing, my lord. When the
Change 1 into 2.
when the certificate
14 and 17 made 14, 24 and 27.
24, my lord. 8 October 35, 8 October 1999, my lord. And date of registration is 1/11/1999. There is no scope of mistake there. Sometime happened, my lord. I should not say it before the my lord. I found when certificate has been taken later on, my lord. Just before May 2 months.
Okay, you give the protection which is there and then you on the data. And data thing, and in the meantime, file your affidavit.
Notice to go to the private.
And my lord, if your lordship, my lord, yes,
Now the mother will also come with a writ petition that no action has been taken in her affair against the daughter. Heard free NNP of the Senate Council for the petition. Petitioners. The case projected is that the petitioners who are married and have entered in marriage are being harassed by the family members of the petition number 1. This court by order is 15/11/2020 and direct the United State Council to obtain instruction on the aspect of steps taken in the case registered case in the FIR lodged by the petition, which was registered as Chanmari case number 411 of 2020 under section 90/3-2/5. And State Council has submitted that as per its investigation have been done in case caused by petitioner in which the accused person have been examined and it recorded, visit the place of occurrence, get draft sketch map prepared from our neighbor's exam. The case stated to be under further. This court has also been informed, the State Council has also informed that the mother of the person has also filed an FIR against the petition, which is registered as PLPS MMR number 59 of that that is that notice should returnable by 4 weeks. 3 and to submit State Council access to 1 to 4. Response numbers 1 to 4. That extra copies have that notice issued to the court by registered post step with 3 days. The earlier order of the court to follow the mandate laid down by the Honorable Supreme Court, the case of Latas, and another reported chairman and police will ensure that no harassment landed of citizen. copy of permit for Mr. Chaudhary, you can take this back. Delhi High Court.
In this matter, I have received the instruction, my lord. It was erroneously done, my lord. Take on video.
I think some steps have been taken by the registrar.
I think so. Registry will take steps, sir.
The doctor is there or not? Report.
There, my lord, at court 2, my lord.
Heard MS Prasad and counsel for the petition. Sarah. This court, by order, it 17/11/2020, had directed the understanding counsel, Guwahati High Court, to obtain instructions in regard of Sarah. Each kid asked, learned standing counsel has placed on record a written communication dated 22/11/2020 issued by the registry of court, whereby the error pointed out has been acknowledged and the learned standing counsel submits that steps should be taken to rectify the same and call back for the record of the appeal to be adjudicated in this court. Court of Sarah. Considering the aforesaid and also the development which has taken place, this court is given that no further and that there is no requirement for any further adjudication. This according to the court of in terms of the communication dated 22/11/2020.
Well,
Okay.
deeply.
The petitioner were elected as a board of director of Food Bozali SS Limited on 19/1/2023. Also knows that as part of section 39 of the Assam Cooperative Societies Act, board of directors are required to hold their AGM within 30 September 2023. Also, accordingly, on 27/8/2023, they have decided to hold the AGM on 16/9/2023. But and accordingly, that resolution was approved by the ERC. But on 16/9/2023, due to lack of required quorum, the meeting was postponed to 24/9/2020. On 24/9/2023, though all are the present, Lordship, but what happened, Lordship, may kindly peruse the case number 70, Lordship. The observer report.
Yes.
With due respect, this is to inform you that the
Now the
general
one-man committee has been appointed.
yes, sir. Lordship, may kindly peruse the page 70, Lordship.
70.
With due respect, this is to inform you that the general meeting of the committee for the year 2022-23, which was held on 16/9/2020, had to be suspended due to want of quorum, as only 47 members have casted their attendance. Moreover, few shareholders and some non-shareholders have created an unwanted atmosphere and insulted the president, and they have taken away the microphone from the hand of the president. Subsequent thereto, the president decided to hold the meeting again on 24/9/2023 in the same venue and time with the same agendas and displayed notices in the notice board.
As per the said notice, few shareholders and non-shareholders by being present in the place of meeting on
24th, you could not hold the meeting because
Yes,
of
Lord.
obstruction.
Yes, Lord. And therefore, at the instance of the magistrate, Lord,
We have read this.
it is not that the Lordship, one line, Lordship. As the few shareholders, non-shareholders by being present in the place of meeting on 24th, in addition of shouting "President Go Break" slogan, block the entry of the president into the place of the meeting who came for the meeting, and also block the entry of the shareholders and created a noisy atmosphere. Though the personnel engaged in the place of the meeting from the end of the administration to control of the situation, can you please the mark does that control of the situation, the magistrate who had done here from the office of the deputy commissioner by considering law and order situation, the general meeting was declared suspended till the time of date is not given from the office of the deputy commissioner. The secretary was directed to announce.
Where is the one-man committee?
Is 73, Lord.
Next to
4th October.
Yes. But till that, they have not published the notification. We have made this government. It is the magistrate who, at his instance of intervention, the meeting was suspended.
What's your term?
5 years on 19/1/2023, Lordship, we are elected. Our term is till 2008.
For the petition. The petitioner are the directors. All of your directors.
Yes, yes, sir.
Directors of the
Bozali.
Bozali Samabaya Summit Limited. The district of Bozali. Under section 39 of the Assam an AGM required to be held in every year, and so far as petitioners side is concerned, state AGM must be held on or before 30th of September 2024. In the case of the petition that such AGM was distributed on 16/9/2020, on which date the same could not be held due to want of quorum, and accordingly, the same was rescheduled on 24/9/2020. On state date, 24/9, though the meeting was right convened, there were obstructions by certain unauthorized persons, which were taken and recognized by personnel deputed by the authority, who ultimately had suspended. The grievance of the petitioner is that for no fault of the petitioner, the AGM could not be held time and without the consideration the state aspect, the impugned order has been passed on 4/10/2020, by which the board of directors of the society in question was held to be automatically dissolved, and a one-man committee has appointed to convene the AGM of the election within a period of 90 days. The Colita, the learned counsel for the petitioner, has submitted that under the aforesaid facts and circumstances, the impugned order is not justified at all, inasmuch as the situation and circumstances present on 24/9/2020 was within the knowledge of the authority, And therefore, it was incumbent upon the authority to create a conducive environment to hold the AGM, for which the petitioners cannot be found culprit of that. MS has worked the learned counsel appearing for the Corporation Department, however, submit that the order dated 4/10/2020 has been issued in accordance with law. And in any case, sufficient time has elapsed from state order. That notice be issued returnable on 5th of January. MS Box returned standing counsel.
On behalf of Mr. S. K.
Learned
Talukar.
counsel appearing on instruction of S.K. Talukar, standing counsel, but except we have response number 1, 2,
3, 4, 5, 6.
3, 4, 5, 6 also, I think. 6. 6. Whereas Mr. and Mr. State counsel except for number 7. There are extra copy of the written of the learned counsel within 3 days. That step can preserve the notice of the respect by reset for para the Purita and counsel for the petitioner place for ministry model. After hearing the party and on balance the while the order dated 4/10/2020 pertaining to the appointment of the one-man committee is not state, it's direct that till the returnable date, no steps be taken for holding any AGM of the election to constitute a new board of directors. He submits that the present board was constituted only on
19/1/2023.
19/1/2023 and the tenure is of 5 years.
May it please your lordship. My lord, here the petitioner is a ward commissioner. If your lordship in the Hailakandi district, I take your lordship to page 6. There are 16 wards in Hailakandi. My lord, I've given a chart. I am from serial number 1. My population is 3,181, and your lordship will find that different wards have the different populations are there. Some are 1,000, some are 2,000, some are 1,500, as such, my lord. The central government by a notification has, under the 15th Finance Commission, has submitted some kind of a fund around 2 crores, more than 2 crores, to be distributed in the wards to be for the development of the wards, my lord. Then, my lord, on page, your lordship will
Your
find.
grievance is that by distributing the funds, the population pattern has not been looked into.
My lord, and the guidelines also says it should be population wise. Otherwise, some will get more, some will get less. That is, my lord. And on 28, my lord,
Guidelines also says that it is the population which will determine the amount of
my lord,
the proportion of the funds.
my lord,
That has not been followed.
not followed. And my lord, on page 40.
Now, is the distribution already made?
No, on 28, my lord, page 45. Your lordship will find.
Page 45.
Page 45, a monthly and ordinary meeting
But
of
28 was long time back.
28/11/2023.
Page 45.
Page 45.
Yes, what is it?
Type it. A monthly ordinary meeting of Hailakandi Municipal Board will be held on 28/11/23 at 12 noon in the office of undersigned to discuss and dispose of the agenda.
Yes.
I have the instruction. That has been passed by the chairman. I am not representing the chairman.
Chairman has heard PKR to the current council for petition. The petitioner is an elected ward commissioner of ward number 1 of Hailakandi Municipal Board. In the case of the petition, that as per population pattern, comma, it is the word of the petition which constitutes the maximum number, which constitutes the highest population, with 3181 members. The demands of the petition is with regard to the distribution of funds allotted by the central government. It is the case of the petition that while the guidelines for such distribution stipulates that is the population pattern which is taken into consideration, comma, the state distribution has been sought to be made in an uniform manner, which the word of the petition would be adversely affected. So that notice should, that notice should returnable. So short date on 15th of December.
Can you take justice service, my lord?
And to serve, then it state council accept 1,
2, 7.
2, 3, 4, 5, 7. That talk of him within 3 days. That's the step for service of which is the Roy Choudhury Senate Council praised for an interim order by referring to the notice dated by referring to Annexure E, which is a notice dated 2011-2023, is submitted that the meeting of the board is scheduled on 28/11. On which date, comma, final decision for distribution is likely to be taken. Considering the above, comma, it is directed that in the meeting stipulated on 28/11, no resolution be taken towards distribution of the funds, and the aforesaid interim order will be effective till the returnable date on which date, comma, same will be reconsidered after receipt of instruction. Orderly. The Roy Choudhury pays for liberty to serve justice service upon the response number 8. Such liberty is granted, and the justice service, however, but the proceed to the registry of the court and notice accompanied clearly the next step as 15. 12. The petitioner is also required to file an affidavit in proof of such justice service prior to the next.
My lord, can I make a dear, my lord, if your lordship does it? My lord, can I get a certificate copy of the
That you need not make a prayer. All people will get the certificate copy.
All right.
Yes, contempt.
Yes, ma'am. Here, my lord, for non-compliance of the honorable court's order, lordship will find at page 15, my lord, the relevant portion, my lord, at 19.
Yes.
The compensation has to be paid, my lord, within 6 months from the date of passing the judgment, my lord, from the date of receipt of the copy of the order. but they have not done anything else. And to that effect, my lord, I have submitted my application, my lord. That is on 20th January 2023, and the joint director had later dated page 22, lordship. It was also forwarded to the director, health service, my lord. They took my 8 bighas of land, my lord, patta land, my lord.
Now there is a communication of February 2023 by the.
Thereafter, nothing has been done, my lord. Since the joint director from Dhemaji, it has been forwarded to the director for complying of the honorable court.
For the petitioner who has complained of non-compliance, the director contained the order date 25/11/2020 passed by the court with WP 1087 complaint by the order from a court that direct that compensation to be at the market rate within a period of 6 months. Which Switzerland has submitted that though a communication was on 2/2/20 by Joint Director of Health Service, Dhemaji, to the Director of Health Service, no further action has been taken. For compare that notice returnable by 40 less steps taken for service upon registered for step within 3 days. Public. Are there any matters, contempt matters where notices are being put? We'll take these matters immediately at court. Contempt are listed as orders nowadays. Like your matter, there may be somebody else. Please inform.
Lordship, one prayer. I beg to mention item number 30. Other part is there. Lordship, kindly matter may be taken on first week of December.
Where are you mentioning now?
Lordship, my senior is out of station.
Can you make a mention now?
Consent was not given to us.
Make a mention when the matter reaches recommended you.
Report also are the shareholders of Cooperative Citibank Limited, and they are active by the order dated 10/10/2023 at page 32. Lord. And that order is preceded by a complaint which was lodged on 6/8.
Page 30.
The order is at page 32. Lord. Annex 2.
32.
Lots.
Please.
Lots.
Please.
Lots. Pursuant to the government letter dated so-and-so, and the enclosed petition dated 6/8/2023, submitted by Sri P. Bosso and 3 others. I, Sri Narayan Kaur, IS Register of Cooperative Societies, in exercise of power conferred under Section 88(1) of the Cooperative Societies Act 2007, do hereby appoint Sri Nilotpal Gohai, Deputy Registrar of Cooperative Societies, Head Office, Khanapara, Guwahati, as the inspecting officer to conduct a detailed inspection into the overall functioning of the Cooperative Citibank Limited, Guwahati 3, with special emphasis on the issues raised in the petition dated so-and-so, referred above, and after giving all concern and opportunity of being heard, the inspecting officer shall submit a report within 15 days. So-and-so, and so-and-so will assist them. This is the order law. And
this was of 10/10. What has happened?
The 10/10 thereafter, Lordship, it was communicated to the chairman and the MD of the bank. Lordship.
Okay.
It was not coming into our knowledge. When as and when it came to our knowledge, we approached the Register Cooperative Societies immediately. Lordship. That our representation at page 33, Annex 3. We have raised all these issues that the persons who are starting with 1P Bosso, neither he is a shareholder, nor he is anywhere associated with the bank.
Okay.
So it is an anonymous complaint, Lord. And your lordship knows it very well.
So
When
what is your grievance now?
grievance is that, lordship, the office memorandum which I have annexed at page 36, annex 4, the office memorandum with regard to anonymous complaint, how it is required to be dealt. The complainant,
Mr. Das, you are going one step behind.
lordship,
This order is of 10/10/2023 by which 15 days time was given to complete the inspection.
lordship.
What is present stage?
Inspection has been completed. Not an inspection, lordship. The one person, Nilutpal Gohai, respond number phone one, fine day he came to the bank. He seized all some internal documents of the bank, which is not privy to the with this particular inquiry, Lord. And as assuming the order is correct, Lord, there was a direction to give hearing to all concerned, opportunity of being heard. Nothing.
You challenge the final order outcome.
No, lordship. When the basis of the instant complaint is not supported, is violative of the guideline, lordship. The guideline is clear, lordship, at page 33.
So what is the prejudice you are suffering?
No, lordship, it will if the entire process, the starting of the process is illegal.
No, what prejudice are you suffering?
No, we are
Only
the
because you
shareholders.
come up with some case will interfere.
No, we
What
are
is
the
the prejudice?
we are
The administration, the affairs of the bank is directed to be inspected by the registrar of cooperative society. Why are you afraid?
No, we are not afraid.
Then-
We are the shareholders. We have
Shareholders?
nothing with. We have
How are
nothing.
you ordered?
We have
You
nothing
should
with.
be very happy
You know, lordship,
that the fair process is being conducted.
no, lordship. The thing is that the allegations contained in the complaint, we are nothing to speak
Who are
on
you?
it. We are the shareholders.
How are you connected with the inquiry?
No, we are the shareholders.
How are you
Shareholder,
connected with the inquiry? Shareholders.
shareholders, lordship. The shareholders are the basic integral part of the bank, lord, the
No,
cooperative
how
society.
much share are you holding?
Lordship, that knowledge I don't have, but we are the
What locus do you have to challenge?
no, lordship. What the
You are set up by whom, Mr. Das?
lordship?
Who is behind you?
No,
You are
lordship.
dismissing this with heavy cost.
No, lordship.
Yes.
No, lordship. The thing is that the
What show us your locus?
no, lordship.
Show us your locus in coming to the court in obstructing a way of inspection of the cooperative bank.
No, lordship. The thing is that if the office memorandum, we have raised this issue before the.
Who are you to raise this issue?
We have approached the RCS, Lord.
Now, who are you?
We are the shareholders of the bank, Lord.
We did us current concept for the.
Lordship, lordship may take the matter after a week, Lordship. I'll
We are imposing heavy cost upon you. You have misused the process.
No, Lordship.
You are being set up by somebody. It's apparent.
No, but we are not set
Sorry.
up by someone.
Did us current concept for the petitioner.
Lordship,
Also heard.
it may be taken after some time. Maybe taken. Let me take the instruction.
We have, it's on your request that we are giving you out of turn hearing. Mr. Das,
Lordship,
we are not going to adjourn this matter for a moment even.
No,
This was not in the list.
No, Lord.
It's at your instance we are taken up unlisted. Sorry. Did us learned counsel for the petitioner. Also heard. Free SK Talukdar. Learned standing counsel. Corporation Department. Full stop. This matter has been taken up for motion out of turn on the basis of a mentioning done this morning, determining the matter to be urgent in nature. The petitioners, who are two in numbers, claim that they are shareholders of the City Cooperative Bank. Full stop. The grievance of the petitioner is in respect of an order dated 10/10/2023 passed by the Registrar of Cooperative Societies, Assam, by which one person, by which the Deputy Registrar of Cooperative Society was appointed as the inspecting officer to conduct a detailed inspection into the overall functioning of the Cooperative City Bank Limited, Guwahati, with special emphasis on the issues raised in the petition by dated 6/8/2023. The inspecting officer was directed to submit his report within 15 days and was to be assisted by 2 other officers of the department. The grievance of the petitioner is that the aforesaid inspection has been directed on the basis of a complaint caused by certain persons who are not connected with the affairs of bank in question. And in this connection, Reliance has been made on an office memorandum dated 18/10/2013. Full stop. It is submitted that by the first memorandum, guidelines have been laid down with regard to complaints in Ministry of Public Department. Full stop. Department wherein a guideline is also there not to take any action on anonymous complaints. Full stop. Para 3. Alluder Senate Counsel for the department, however, submit that apart from question and that apart from the fact that the petitioner may not have the locus to maintain the writ petition, the inspection was directed to be completed within 15 days on 10/10, widely ordered it 10/10/2023, and as on today, more than a month has passed, and therefore, for all practical purposes, there is no cause of action to be adjudicated.
Another submission I have, the power to inspect is prescribed under section 88. So this statutory power, cannot be diluted by office memorandum. And this power is absolute under 88. It's not conditional,
He further submits that the aforesaid order dated 10/10/2023 has been passed in exercise of powers under section 88,
Subsection
bracket
1
of the Assam Cooperative Act 2007, and no issues has been raised with regard to the competence of the registrar. After the rivals have been considered, the status of the petitioner, the respondent bank, is that they are shareholders. It is what, however, impedes this court is the cause of action, if any, which can be espoused by 2 shareholders with regard to inspection on the activities of the respondent bank. Though a submission has been made that the inspection has been done on certain complaints by persons who do not have any stake in the bank, the power under which the inspection has been done, has been directed, is a statutory power, which can also be exercised suo motu. This court has further noted that while 15 days time was granted to submit the inspection report by the impute order dated 10/10/2023, more than a month has passed, and therefore this writ petition is otherwise also without any cause of action. This court is also having grave doubt on the locus, on the bona fide of the 2 petitioners to raise the issue of challenging an inspection on the overall functioning of the bank in question, which is otherwise necessary to be done on a routine manner of a financial institution. In view of the above, this court is of the opinion that no enforceable right has been violated and accordingly the writ petition is dismissed. Full stop. Considering the facts involved and the background, this court also imposes a cost of rupees 25,000.
Lordship, the cost may not be imposed.
Right. Think twice before you come to the very necessary. Yes.
Yes, in this case, Your Lordship, I want to file my counter to the IA, Your Lordship.
IA is set for the first time.
Yes, today is the first.
Lordship,
Yesterday I received the copy.
My lord, technically they have filed a IA, but the stay order in operation is for the forest department.
Yes.
And it's only till today. And only the whole matter hinges on the power of the forest department to evict encroachers, under which authority. Lordship will check the history of this litigation. There are 3 orders. It was listed 3 times. And leaving aside, let us forget, my lord, this stay application for a moment. But this is because their project has not been stopped. It is the forest department who has been stopped from evicting the petitioners which are encroachers upon forest land. And my lord, they're stopping a construction of a high power transmission line between 2 states. They are demanding compensation, which can be decided later on. But my lord, this construction is complete. Everything is complete. Lines need to be charged. They are admittedly they are encroachers, madam. They are demanding Zirat.
Lordship, what happened in this case? I have filed the IA on behalf of NHI district. After the passing of the interim order, stay order, Lordship, on 15/8, our whole project has been stayed. We could not go ahead with the construction work because 35 towers are there, Lordship. On the
What is your prayer in the
Your Lordship, I have submitted 2 papers, Your Lordship. These land are not forest land, Your Lordship.
No, we are not there. What is your prayer?
My prayer is that at this moment, Your Lordship, it is a project of national interest. We are ready to vacate, but it is not a forest land. Earlier also, they for widening, they have acquired some portion of our land. By drawal of land acquisition case, they have paid us compensation. Now, within 20-30 meters inside our plot, they are drawing the electric line and erected 13 number of posts. So there is a process, Your Lordship. Let them initiate the acquisition process and access the compensation and pay me compensation. We are ready to vacate because it is a project of
Can
national
you
interest.
claim that payment of compensation is a precondition for vacating?
They have not even initiated any land acquisition process, Your Lordship.
But when have you to come to the court? Have you come to the court at the starting of the project?
Yes, Your Lordship. There is
After
another
construction?
petition. There is
After
another
construction of the line.
There is another petition, Your Lordship.
Yes.
3721/2023.
What has happened there?
That is for compensation. That is notice has been issued. That is pending.
No, when did the process of installation of the towers start?
Immediately we filed that writ petition, Your Lordship.
When?
Not before.
I have that.
Towers have been completed within 3 months.
Yes, Your Lordship.
Already completed, Lordship.
No.
This is 3 months only.
No. Immediately when they were started erecting the post, we approached this honorable court.
When was it?
You
have approached this court?
I have that writ petition, Your Lordship.
2019, my lord.
No.
2019, my lord.
2019 was for widening.
Writ petition, when was it filed? In August?
It was filed on.
In August?
August.
Yes.
When was the process started?
Process started in July.
2019, my lord.
No. It was filed in June.
No, you have filed on August 11th.
No, earlier writ petition.
That is for compensation.
That is for
Now
compensation.
this one is you are challenging the notice.
After issuance of the notice.
When was the project started?
Project started, they initiated the process in May, June.
Which year?
This year.
This 23?
Yes. And there, what they are stating, Your Lordship, that was for widening the road. That part they have initiated land acquisition case. They have assessed compensation and they have paid us compensation.
How much land are you occupying? 3 of you?
Yeah, not 3. We are for the entire 4 villages, Your Lordship. 4 villages. These are Khashi villages and they are residing since last 300 years, since the time of Kathari Kingdom. They are hill dwellers.
How many of you are there?
We are between all the villages, 4 villages. We are the village headmen.
3 persons are there.
We are village headmen, Your Lordship. In the first paragraph, we have stated. In our petition, we have already stated, Your Lordship. Now, the matter can be easily settled, Your Lordship. We are ready to vacate it because it is a project of national interest.
Yes,
But
Lord.
without initiation of the due process of law, they are doing this, Your Lordship.
Your vacation,
Not-
the
Your
continuation
Lordship-
of the project will not affect your right to fair compensation. That will clarify.
Your Lordship,
will not continue with this interim order.
Your Lordship, the damage has to be assessed, Your Lordship.
It will be done.
After cutting down, who will assess, Your
It
Lordship?
will be done.
Yes.
But can you stop a project of this?
No, we are not on that. We are not on that.
Then let us vacate the order.
And the two documents
Who
I
has
have,
filed?
Your Lordship,
Who
two
has
documents I have submitted that proves that those are unsurveyed land.
Yes, madam.
Those are
Exactly,
unsurveyed
that's
land,
the
not for
point.
forest
Unsurveyed
land.
where their rights come. Where
They,
are their rights?
they are
Unsurveyed land.
unsurveyed
No
land,
dedication.
we are occupying since last year, we are paying taxes.
Since last year.
Last 300 years.
300.
Take it.
No, our road project has been started. in
300
a year.
years you were there in from 300 years.
Oh, for others.
For further.
Yes, Your Lordship. We are hill dwellers.
No, no.
We are residing there since the Kathari kingdom, Your Lordship.
Lordship, I have the photograph.
We are
of the-
Kashi peoples residing there, and Your Lordship, the letter which I have submitted.
Overwhelming public interest is a concept.
Yes, Your Lordship,
For
I
3%,
admit.
project is not going to suffer, Mr. Mazumdar.
I admit,
Sorry.
Your Lordship.
Yes, Lordship.
Earlier also they have acquired.
If you have agreed, you just sit down.
Because
No, Your
But,
Lordship.
who has filed this?
I have filed this Lordship.
Or
Yes,
MS
number
R
eight,
Bora
Because
done it
it's most important,
council
it is connecting the east-west
for
corridor.
the applicant who has approved this court, who has filed this petition for vacation plus modification of the interim order dated 25/8/2023. Asked in the connected writ petition WP 4700 of 2020. By the aforesaid interim order by the officer order, while notice was issued in the writ petition, it was directed that till the next date fixed, the petitioner shall not be evicted from the land in question. MS Bora, the learned counsel for the applicant, which is the NHICL, has submitted that the land in question is connected, that submitted that the NHICL is entrusted with the construction, with the development of a stretch from Balatera in the district of Kachar to Harangazao in the district of Dima Hassan, which is a part of NH 54. Full stop. The construction is of a 4-lane facility. Full stop. Affordable facility which is a part of the east-west corridor. It is further submitted that there are 34 towers of Power Grid Corporation of India, 34 towers of the 132 kV as topic the half-long dash DD pump transmission of the Power Grid Corporation of India. Full stop. Since the towers were on the way and situated at Hillock, it was necessary for paving out the way for construction of the national highway in question. Full stop. It is submitted that due to the interim order, even the work pertinent work connected with the transmission line has also been stopped. Full stop. Supporting the prayer made on behalf of the NHICL, we The Gokul Land Council for the Forest Department has submitted that the rights of the petitioner to continue to possess the land is itself disputed, and therefore they cannot cause any obstruction to a process of development.
And also, my lord, these lands fall under Borail Wildlife Sanctuary, wherein, my lord, Forest Conservation Act permission has also been taken for the central government.
He further submits that there is a pertinent issue that the land in question is a part of the Borail Wildlife Sanctuary and necessary permission under the Wildlife Conservation Act.
No, Forest Conservation Act 1980.
Forest Conservation Act 1980 has also been taken before initiation of the work in question. Sri R.K. Talukdar, Land Council appearing for Power Grid Corporation of India, has submitted that due to the interim order question, even the works connected with the transmission work has also been put to a halt. He submits that how many towers? 32 towers.
In our portion, 13 towers.
He submits that 34 towers have already been constructed, and the work
13 is under the
and out of those 13 towers are under the forest land, which is the subject matter of the writ petition. Sri Mazumdar, Land Council for the opposite party petitioner has, however, submitted that the land in question is under the possession of the petitioner since the time of their forefathers.
It is not a forest land.
And disputes that the same is a forest.
Not forest land.
Dispute. He has further placed on record certain documents
which itself
issued by the NHIDCL as well as the Hill Mozadar Qatar, which as per him would show that the land in question is unsurveyed land. The rival submissions made by the London Council for the respective parties have been duly considered. The writ petition is filed by 3 petitioners only, while the petitioners, while the Learned Council for the writ petitioners have submitted that they are the village headwoman and represents the village,
4 villages.
Represents 4 villages, the prayer in the writ petition is prayer which as follows. A perusal of the prayer would show that it is the notice dated 21/7/2023 which has been put to challenge. This court has been apprised that the notices were issued much after the work in question had started, and the principal grievance of the writ petitioners is with regard to adequate compensation, adequate of the fair compensation. Sri Mazumdar, the Learned Council, has fairly submitted that though the concern of the petitioner is to ensure that fair compensation paid to them, he submits that till date no recognized process of acquisition has also been initiated, and the land in question are under their position since the days of their forefathers. After considering the rival this put to the opinion that do certain rights of the petitioner, of the three petitioners may be involved. There is an overwhelming public interest with the project in question, which not only encompasses the issue of the national highway, but also the transmission, the 132 kV transmission line, which has come to a halt because of the incentive model. It is a subtle law that rights, if any, of certain individuals has to give way to overwhelming public interest. And in this case, it is not dispute that the project in question concerns our national highway as well as a 132 kV line of the Power Grid Corporation. That in view of the above of the opinion that there should be no restriction on the work of construction of the project of the national highway in question, as well as the transmission line of the Power Grid Corporation and the interim order dated so and so stands modified according to para. It is however made clear that vacation of the interim order as directed shall not affect the rights of the petitioners, if any, to claim and be paid fair compensation in accordance.
That eviction part also, my lord, not something that we should carry on eviction because they are below, just below the line.
Below the line.
We have a order.
One submission, your lordship.
My lord, sir.
Regarding the construction of 4-lane, your lordship, they have already acquired, they have paid compensation, we are not disturbing. Over the remaining portion of our land, overhead, they have carried out a electric line, your lordship. So this notice already shows it is admitted fact that they earlier
We
have
will consider there is the Telegraph Act,
earlier they have
Telegraph Act as per which we will be allowed. Awarded
regarding the compensation part, they may initiate the process, your lordship.
Always, my lord.
So I am paying for taking this matter along with WPC number, your lordship. 3721.
The interim order passed I and for past has been vacated in I. It is submitted that there is a connected petition WPC
3721
3721 of 2020. This petition allowing WPC 3721
January 11th of our
13.
11.
Out of 34, 11.
11.
Always.
May I please your lord?
Yes.
My lord, this honorable court by order dated 14/12/2022 passed an order to the respondent authorities to the petitioner should produce the certified copy of the order to the deputy commissioner Dubli, and the deputy commissioner will do the needful. Accordingly, the petitioner submitted the representation to the deputy commissioner. Deputy commissioner already written a letter. So, as subdivision officer written a letter, my lord, page 40.
Yes.
For demarcation of the land.
Yes.
As per the order of the honorable court, my lord. Yes. But the same has not been complied with as of now, my.
Yes.
Yes, Lordship. We have received an instruction from respondent number 3, that is settlement officer Dubli. Here it is mentioned that resettlement operation is in respect of Bilasipara revenue cycle has already been closed. But when it is closed, that is not mentioned. This instruction is
So he is paying for demarcation.
demarcation.
Not a question of settlement, resettlement. Go land controllers, go there, identify the land in question, demarcate it, put boundaries.
Yes, Lordship.
Therefore, that part should not take out the entire exercise of resettlement. Have your officers understood the orders or not?
sometime required located.
It is
Two
this
weeks and-
initial order which Mr. Talukdar has pointed out
Yes.
is of 12/2022. We are in almost 12/2023. Almost a year has passed. And your letter by the circle officer is immediately thereafter 10/11/2022.
Yes.
22.
In the additional affidavit he has given. It was sent to the, no, the letter by the SDO.
Yes.
To the circle officer. Now circle officer has to act. Take instructions. The IA Talukdar founded substation submitted that pursuant to the order dated 14/12/2022, comma, the petitioner had discharged his obligation. He has further stated that upon submission of the documents by the petitioner, the SDO Civil Bilasipur had issued communication dated 10/11/2020 to the circle officer for doing the needful in terms of petition. It is submitted that no further action is prepared. As it is for 3 weeks time to obtain drug regarding by the circle.
Yes. If your lordship kindly fix a date, we can.
3 weeks. 3 weeks. Last week. 3 weeks. 3 weeks. Otherwise, fix the date is there.
Yes.
Okay.
Both the case can be disposed of without it is admitted among.
Yes. What is it?
Total requisition pending below 22,37,562. They admitted that this amount lying at page below 22.
And item number which one?
In item number 26.
Tudi Prahar.
Page? The admission at page 18 below. Whatever I claim that they admitted this as a fact.
It is. It's a reference of position.
Yes, sir.
Yes, yes.
Paragraph 4, Lordship, page 16.
When did you release the amount?
Paragraph 4, page 16 of our affidavit.
Yes.
Lordship. May I read? That with regard to averments made in paragraph 2 of the petition, the answering deponent begs to state that averments made therein is a fact. In this context, the concerned record to
That is the admission. We have read this.
Yes, formally.
You have written for sanction.
Yes, sir. We have written for sanction and allotment of funds to make payment to the petition. And it is stated that payment of higher charge will always depend on the sanction and entitled amount. The
Who will
deponent
give
party-
sanction?
Sanction,
Who will give sanction?
department with sanction.
Huh?
Department with sanction.
You are representing the department.
Yes, sir.
Then you are writing to yourself. Give the sanction matter and say, cannot find fault with your own department. The Deputy Commissioner of Police writes that yes, their claim is justified and have written for sanction.
Yes.
This affidavit was in July 2020. We are in November.
Yes,
Where is the sanction? Or at least what steps have you taken? Have the department taken for grant of sanction or at least consideration of the case for sanction?
sanction amount yet to receive, Lordship.
No, who will receive the instruction? Only you only.
Yes, sir.
You're the government council. You cannot pass the buck. We'll dispose this of. They give some time.
Yes.
And the next one,
Next one also same, my lord. Though my claim was
affidavit file.
affidavit file, my lord.
Here, Lordship.
Here they admitted at page 18, this sanction, they
But-
sought for sanction, my lord.
But here we have two bills, regarding two bills, there is a confusion. We have, here it is stated that we have not that received that two bills. That is mentioned.
Those two bills can be.
Out of that, my lord, I claim 73 lakh. They said that they paid already 8 lakh 14,000. Balance is 60 lakh 97,250.
Even for the time being, if that 8 lakhs is taken away, 62 lakhs is still there.
60 lakh 97,252.
Heard. Yes, internet count for the just purpose. It that's one number 3. Is the respondent who is Deputy Commissioner of Police Secretary one Komasa has to fight. Who is the respondent has also filed an affidavit of which through the Deputy Commissioner of Police Administration Komasa. Considered factor of comma E and of this one and as agreed by and as agreed by land council. So it is taken up for disposal at admission stage. The petition owns two vehicles. City bus.
City buses.
Bearing registration number AS01 HT -140 and AS01 HT 2529, which were requisitioned by the of the Assam requisition and control of vehicles.
No, my lord, no. It's under higher charge.
Not requisition.
Not under, not requisition, my lord.
It is
It is always under higher charge.
None of the time. The state vehicles were taken on hire by the respondent and in connection there is an outstanding bill. There are outstanding bills, total of which is rupees 22,37,5. The bill not being cleared from the petitioner has approached for the Kotak Children Council for the petition that the pay is not due and therefore appropriate orders passed by. So he has also referred to the affidavit of dated 19/7/20 filed by the respondent of the three, in which the claim to the has been admitted to Sarah MS as Guru, the state council has widely submitted that the claim of the petition is not included in the as of the evidence from the affidavit of filed as the country on 19/7/23. The United States Council, however, submits that the proposal has been sent for due sanction and only after the sanction granted from the amount and the release of the petition. The affidavit, this court, after hearing the parties, this court was accused that since the claim of the petitioner is not disputed as such, and rather admitted, the affidavit in opposition, adequate orders can be passed by the court because of power under Article 2. So, a stand has been taken on behalf of the respondent that the amount, though admitted, has been sent for sanction amount. The court has noticed that the proposal were are of March and June 2023. And in the meantime, sufficient time has elapsed. In view of the above, the inspection is disposed of the direct release of the admitted bill of the petition as mentioned in paragraph 7 of the affidavit of petition dated 19/7/2023 within a period of 90 days from today. It's very clear that the issue of grant of sanction is to be worked out within the supported period and the amount released within time to allowed. There are 4 vehicles.
It's 6 vehicles.
6 vehicles after the paragraph 3. All city buses.
All city buses, my lord. Here they admitted 60,97,252.
Affidavit of position of date, first of September.
Page 18, my lord. Sanction and
Which were as per them, which bills have been paid to?
and at page 19, my lord.
Yes. This 7 bill.
Yes, my lord. Take it.
How much is come?
It's come around 8,14,375.
Total how much have you claimed? Otherwise,
They are
your claim.
my claim is 73,75,026.
Though the petitioner has claimed an amount of fees 73,75,023, MS Borua, Children State Council has that in the meantime, 7 numbers of bills amounting rupees 8,14,375
375
has been sanctioned and paid.
Paid.
In view of the direction clearly bill would be for the balance amount
Of rupees 60 lakh.
balance amount which has been mentioned in paragraph 7 of the affidavit of the dated.
Yes, may please. On the last occasion, respondent took time for filing affidavit matter, but no affidavit is filed.
Affidavit is ready, Lordship.
Mr. Gupta, what's the matter about?
So this matter relates to allotment of land mal.
Allotment of?
Allotment of land mal.
Last occasion, petition also directed to to file additional affidavit.
Have you filed additional affidavit?
So my lord, I could not, they have, do not have the documents all the.
You said that you have the relevant documents you want to place on record.
My lord, but later on I have inquired, my lord, they do not have all the documents.
Can we go ahead? Matter.
But
You file your response. We'll say that he does not have any other document. Do this put by the order dated 15/20 has been referred to Sri A.K. Gupta, Senate Council of Petition, to file additional affidavit to bring on record certain relevant documents from the Senate Council for the petitioner submit that no documents are readily available and therefore such petition could not be filed. MSS or you're also there, board lawyer? Both and board lawyer. That's not fair.
And for
As well as Zorro and if run 4 weeks time to file them.
okay.
Oblige.
Like,
May
Yes.
please, Your Honor.
Yes. You are seeking adjournment in this matter.
Yes, sir.
Just take some time.
I'm in my lord's hand.
Have you filed affidavit of opposition, madam?
Yes, my lord. They have filed the reply. We have also filed the rejoinder. The pleadings in that sense are complete, my lord. It has to be heard.
What is the matter?
But this is a matter where there is a show cause notice issued, my lord, where they conducted an investigation under 67, my lord. In the garb of conducting an investigation, my lord, they conducted an audit.
Oh.
They conducted an audit under 65, my lord.
Where is the distinction in an audit?
Yes, my lord.
There is legal distinction. They are affected. Connotations are different. But how are you prejudiced?
Lordship.
What prejudice was?
No, my lordship, prejudice is caused is that's the reason that I made an application because 67, lordship, our law borrows the provisions of 165 CRPC. We made an application to them under 165 CRPC read with 6710, saying that you please provide us with the information. They have not provided that, and one line reply they have given, we have issued show cause notice. That is my grievance, my lord, that they cannot do that.
When can the matter be heard?
Subject to my learned friend.
Mr. Kyle, is he around?
Yes, but Lordship, matter may be taken on the first week of
January.
no,
Jan-
no, Lordship,
December.
December.
The same date can be given, my lord, which was
the
given
date?
in the earlier matter, 5th of January.
As per their means,
The other case which we had 25th January.
5th of January, Lordship. Yeah.
We can have.
okay.
Is there any order?
Yes, Manoj, there is an.
Heard. Be right hand and correct now. Last occasion also you had not
They-
for adjournment.
They had short time, Manoj.
Lordship, he has gone to his native place suddenly.
Where is
Johan.
his native place or industry?
Sorry, Lordship, it's only. Sorry.
He's not going to come back very. January is safe. 1 month. However, a prayer for adjournment is made on behalf of the SP Kyle, standing council, who has gone to his native place. To the right. Standing council has agreed to by the part. The court has been informed that meeting has been exchanged and the matter can be taken up at the court has agreed by the court. This for on 5th of January 20. For the past office.
Great.
For
Yes.
this is a party chair.
Yes. That's what I
If,
want.
if not, well, what? The response number 1.
Yes.
If not, this not this person.
Now, my lord, under GST, I've been told, my lord, at least at the bar, under GST, my lord, what happens? There is a state tax as well as center tax, both. So, lordships both become parties and therefore they get 2 briefs. Whether there is relief sought against them or not. Lordship, please.
Diagram, path,
Yes,
First
Lordship,
one.
Dibrugarh.
Yes. Malad, as per our instruction, Malad, the diagram is okay, Malad, that it's a correct diagram, correct picture they have given.
Is it possible in the junction?
In that juncture, Malad, they have indicated that there is a difficulty on that. Malad, in fact, in the first paragraph, you see the location in the map marked on the red circle. Malad, we have given this map, Malad, is Khanikarh Sajali, and it will not be feasible to set up bus stop at Khanikarh Sajali as it will create traffic hazard and unsafe for road users. But the proposed place which we have proposed near the Jagannath temple, that is from that juncture, it is 500 meters.
To
the proposed in the map, we have shown a place at
from
Jagannath.
Jagannath to this place which were proposed by us.
Yes.
It is 500 meters.
Distance is 500. Difference is 500 meters. So particularly at juncture, they are apprehending that they said that it is not feasible, and otherwise the place which we have proposed it is of only 500 meters. That can be, it will not
From
make
Jagannath temple to the MG, what you call it,
MG.
That how much is it? Will it actually serve any purpose? We
Yes,
have
yes.
if it is proximate.
MGBT is a terminus, their buses can stand. They can wait for hours today.
We are not providing a place
Look.
for facilitating the commuters to alight or get down of the bus. At a place which is very near to MCPT will not serve any purpose. Whether you get down here or you get down at MCPT, not making this exercise which we are trying to do or explore is only to benefit the commuters. If somebody wants to get down and not unnecessarily go to MCPT, then he or she can get down, take the lane by what is the name? Mankata. What was it?
Mankata Road, Mankata Road.
Mankata and enter Dibrugarh.
Yes, at Khanikar, which place we have proposed, near Jagannath temple. This is 500 meters. They can take the Mankata Road, but they have to go.
No, that is
500.
not exactly. Having this a stoppage
Lord.
at Jagannath and going to MTBT, will it make any difference? How far is MTBT from Jagannath?
More than kilometer.
More than 1 kilometer.
More than 1.5 kilometer.
Is that Bora?
Yes. Lordship, if Lordship is holding the map,
Which one?
given by my internal center. Oh.
I think we had given that.
This one. This one.
Yes. No, this is by yes. We have the Google map.
No, Google. This is given by
This one?
my. Yes.
This is Google map. Yes.
Google map. Yes.
Yes.
It's Google map.
This is the correct map. We can refer this to this one. Jagannath temple, Lordship has seen.
Yes.
At the juncture, Lordship has indicated.
Yes, from here to Jagannath is hardly 500.
500. And the MCBT kindly see that they have to come to the main road, then go to the MCBT.
Then also you are, I think, better off.
Because from NH 37 they are taking the bypass. Now what they have stated that they are taking the NH 37. They move the entire town, then come to MCB. But there is no stoppage. As of today, there is no.
Tell me one thing, Mr. Nath.
What?
These are not city buses. These are buses.
Long distance
buses.
Yes.
Which come from the side of here.
Yes.
Instead of taking the bypass,
Lordship.
they will go straight first to MTBT. Correct?
First to MTBT.
Then they will come back over. They'll make a U-turn. Then
They
take a
have to from MTBT. They have to come back and they have to take the bypass again.
they bypass and
Yes.
go towards that Dhemaji side.
Dhemaji side, without entering into the town. Or entering to the town is the difficulty for us. Now what they are doing.
But still MTBT, it is not very crowded.
No.
You get down and these buses will come back long distance bus and take the bypass which if it goes towards Dhemaji side.
Yes. And from Dhemaji side, Lordship has seen 37. If they now what they are doing, they by the red marked arrow, they are moving the entire town and coming to the MCBT. As on today, there is no stoppage. They cannot stop in the town, but they are moving the town. There is no meaning. If there is no stoppage, they cannot take passenger. They cannot allow the passenger to get in. So there is no meaning of allowing them to just move the town.
Yes.
But because impugn order is only curtailing us the stoppages, not we can move through. That is not curtailed. First, secondly, in our previous settlement, we were getting, as per their settlement only, we are getting 10 stoppages within the town. For this settlement, we are seeking only one stoppage in the town for one side. If whether it is Jagannath temple, we have clearly, your Lordship was trying to help us a lot by making us a point in Jakoi also. But these portions are completely barren and covered by tea gardens. And we have not gone there to explain us. They have told it is like Sonapur area of Guwahati. It is no passengers come there, and they have already told us that it is not like Guwahati. Guwahati has city buses for going to that place, but Dibrugarh has no such services. Suppose Lordship would see the Dibrugarh University. Suppose a student comes from Moran, and this place, the juncture of the bypass, the buses reach as 2:30. From there, we have to, suppose it is the bus stand, then the student has to get down in an auto which will charge around 300 to 400. Suppose I am telling, but only and there is no such restriction for night supers, day supers, omnibuses. We are an association who are running under the ASTC undertaking. We are under ASTC undertaking, Lord. we are trying to uplift the ASTC, Lordship. We are under the ASTC. Every bus of our association under the
Just a minute, it's an ask.
Lord.
Suppose a vehicle coming from Moran side,
Moran.
long bus.
Yes.
But just taking a hypothetical example, a student comes, he wants to put the Dibrugarh, and the bus takes a right by the bypass.
Lord.
Then, while he could have reached Dibrugarh University within maybe another 1 or 2 kilometers,
Yes.
he has to come all the way to MP.
No. Now this at this juncture, it is going on. Malab, the bus will stop here. He will cut down there.
Where?
At the
That
junction.
corner.
At the corner. Malab.
But you have said there is no stoppage.
No, there is no stoppage, Malad. Here, if a Malad, assigned place is now as we have proposed, Malad, is given, they can stop there. But in any case, now while going, they are doing that, Malad.
See, from this corner,
Even if
if you want to, if you say that there is only one designated stoppage of long
yes,
distance
yes,
pass,
yes, yes.
and pass coming from Judaism side, there is no problem. The MTBT is just after entering
Yes,
the premise at the area of Dibrugarh.
Lord.
But one coming from Moran side, if you are not, if you cannot go straight, this will be into the town of Dibrugarh. You have to go right by the bypass.
Yes,
That's it.
yes.
And bypass, you come all the way and reach MTBT. Then you are coming away from your destination by around 10-15 kilometers.
No, no. They have to get down. Malad, as on today, what the students are doing? As on today, there is no stoppage. Even if the statement of the petitioner is taken, as on today, there is no stoppage. What the student is doing? They used to stop the bus just in front of the university, Malad. They used to get down. That is what my learned friend is submitting before the Lordship, Malad. Malad, at this juncture, he can get down. For the university student, Malad. And this is not a PIL, Malad. Now, here in this petition, the petitioner is asserting his fundamental right.
No, we are not.
Lordship.
Yeah, we are taking a hypothetical example.
Yes, Malad.
A person
Now-
who wants to resides or he wants to go to a place which is just near the key, which if you come from Moran side, take right for the Dibrugarh bypass. If you are intending to go somewhere near the university,
Yes, or
are you required to come all the way from to NCPT and again go back? No.
Malad, ultimately, while implementing the thing, the buses nowadays, what the buses are doing for university students, they are stopping here before the just in front of the university.
No, it cannot go in front of the university. That circle is prohibited for long distance pass.
No, now they are running. There is no stoppage, assigned stoppage, and that is why by flying the buses, they are creating havoc. That is what we want to stop.
No, this bypass is meant for whom?
Bypass is meant for the long distance buses.
So are they going by the bypass or are
No,
they
not
still
now.
using the?
Right now, they are not taking the bypass. It is the statement of the petitioner that they are allowed to go by the road, the red mark road, but they are not allowed any stoppage there. That is what they are difficult.
That is
Now, what is your action? What's the impute action? Only to they want that the stoppages to be introduced.
Stoppages should be introduced.
Flying is not the problem.
Flying as on today it is going on.
Flying is not the problem.
There is no stoppage. As
No,
on
flying is not the issue, Aduk.
Flying is not the issue.
not an issue. Now
Lordship
it is
will
on-
see the impugn order for one. And moreover, Lordship would see the impugn order. It
Well,
is
the petitioner association is having 120%. There are other associations for 300, 400%. In Dibrugarh,
Then you have one stoppage near the Dibrugarh University, that will anti-match. One at FDPT, which is the main stop. One which is the main, not the stoppage, it's the parking area.
it's a parking area.
Can you have a stoppage near the Dibrugarh University?
Well,
Officially.
we have taken the instruction pursuant to Lordship that in between the town, Malak, there is no wide space.
The university area,
no, we have
university area, I think we, from our personal experience at university area,
we cannot have
Lordship, we have the photos also. We have brought the photos with the place we have suggested. But Lordship would see the wideness of the space. And moreover, Lordship, I'll tell. Now we have come to litigation. Now the government does not want to talk to us that you do litigation, you will not give one stoppage also. That is
No,
the
that
way
is- that is- that is-
we
that is-
cannot settle with such
no, that is-
authorities
that
who
is
are
not-
egoistic and adamant on their.
This is which area?
Kundu, glass corner, no? Glass corner. Kundu? This one, that black mark on the map.
Which area?
Black mark, Pulbagan area.
This you have fixed on Assam.
No, Lordship. Morning, today morning.
Not even a single vehicle.
Today morning. Today morning and this photo also.
At
Today
4
morning.
o'clock.
Yes, today morning.
4 o'clock, no vehicle.
No, I am just showing the wideness of the space. I am showing that just for a stoppage, there is enough stop. Because every bus will not come in the same time.
But this looks like Bhangagar. You're
But I am amazed to see such wide roads in Dibrugarh. Really wide. But because this is the earlier NH37.
This is which part?
Pulbagan area. Pulbagan. Above, near Marwari Patri, black mark.
No, that part, Mr. Nath has disputed that last corner is congested.
It's a written instruction. We have, if anything on writing, they can definitely I will ask again.
On the other day, we were having some other impression. We thought that the entire time was in dispute. If time through the city, through the town is not in dispute, then it's only a question of a stoppage.
What the problem is that they used to stop all the buses.
And that we understand.
Just in front of school, in front of hospital, buses are.
That would be a big concession.
Lot.
We may not encourage that.
But the night super, the day supers, omnibuses are not curtailed. Even the impugn orders are for the associations only.
Associations have not vehicle.
We are ASCC undertaking ultra buses for travelers and ultra buses.
How that night supers are not curtailed to
Yes, I'll show because the impugn order, Lordship would see page 55.
Yeah.
55. It's to the secretary Ujoni Onmilita Ujoni Akham Bus Malik Akhanta Eastern Bus Owners Association and Esteem Bus Owners Association. This is the main at 54.
Page 54.
But implementation, it is done only to the association. I've been told that there is 148 number of night supers and
No, this is only an information to you. It regards an official notification of 15th of March 2023. Where is that notification?
Page
54.
54. That is not 20 for you. Is it 20 for you? It's a general notification.
Yes.
it's a general notification, but implementation part.
This notification was brought to your notice by this forwarding.
Yes.
It is not confined to your assistant.
Yes. But they are moving, they are stopping. That's I'm told.
That is something else. The factual dispute.
Factual.
Action will be taken from our side. If
And,
somebody is not following, we will take action. But here we have said that.
See, can you see page 54?
Yes,
Oppositions of all types of bus and
All types of
travelers.
buses and
Yes.
travelers will be
Only
immediately
CNG is
secured.
curtailed, that I have pointed out. But implementation part.
That Mr. Nath can advise their clients that take action if.
But now it
Yes,
is
yes.
stopping as per my instruction. Basically, Lordship, what I suggest, Lordship has tried to.
We try to explore some options by which this citizens may not be facing a lot of harassment.
Lordship, what I think
But in
is,
fact- in
if
fact-
Lordship sends this matter to the mediation with an official mediator, Lordship.
This difficulty on the part of the university student or this type, these are now submitted before Lordship. These are not part of pleading. So we did not got the opportunity to take instruction from the authority while filing the affidavit. The case projected here, kindly see what the Yes, I have not argued
Mr.
this.
Nath,
Yes.
though this is not
Yes.
in the nature of a care, we are just thinking about the commuters who are using this kind of transport. Whether any option can be explored that other than MCP anywhere else in the road on the road through the city or through the town of Dibrugarh. Maybe on the extreme side, or is it possible? Or in the entire stretch, isn't there any area which is wide enough to have a parking space
Parking
under
space,
regulation?
parking space, Malat, is not possible, but for 1 minute,
Obviously, with the regulation,
One
it's
minute
not
hold.
for taking in passengers, only to.
University side. No, for 1 minute halt.
1 minute hold is enough.
1 minute halt, if possible in the university side.
Yes, yes.
University
You
side.
explored that option.
1 minute halt.
Yes, somewhere near the university side.
That.
Third,
Malat,
we will have another day. You take the option.
or Malat, university side, my friend is also visible.
In your lordship, I have sent some more photos of the glass corner. Lordship, will just see.
No, let your colleagues see.
Malat, this Marwaripatti, Fulbagan, glass corner, all these points, those are
very wide.
Those are inside the town. Those are not visible. That they have already specifically stated. But in the university area, Malat, these things I am told that these are white areas. There maybe. There, if 1 minute halt can be allowed.
One stoppage of 1 minute halt.
1 minute halt for a bus. That.
And you have some officials there, some traffic there, so that it's not violating. Does create a condition.
Correct.
Pursuant to the last order, it is 2020, certain instructions have been up. Three knots, both three knots, the both three knots, as well as empty Bora, understanding of but submit that it cannot be visible to have to introduce a topic at the junction of Jakui and Dibrugarh bypass.
Jokai. At Jokai junction, it is not possible.
Dibrugarh bypass.
And in between
the Bora did not count it for petition. However, that it is clarified that it is only the issue of topic which is the subject matter of and buying of the buses owned by Dibrugarh Town is not subject matter of that. Subject matter of he further submit that there are places on the road through the town, more specifically somewhere near the Dibrugarh University, which will not only benefit general people but also students in particular. The important option this court is that instructions may be obtained by the responsible to explore as to whether the option of having a shopping for of a limited time is a feasible requirement. This when
it was 1 week.
Next Wednesday.
Wednesday is too short now because till Monday is holiday.
Next Friday. Please start.
Lordship, I'll just pray that if the matter is not settled on mediation, Lordship will hear this matter on merit.
We are not settling on mediation.
Lordship, kindly take it on 4th December, Monday. Nowadays, considering the number of vehicles, increase in number of vehicles, possibly they have a plan to move out all the buses from the town. Because the bypass has come out, now bypass has come. So in that
That
case,
is the impression we are having. Long
Yes,
distance bus
Sir,
will
as
not be allowed to just stay in Guwahati.
as on today, as
You have
on,
to take the bypass.
as on today, Malad, in Dibrugarh, it is going on. But in phased manner, we have to take them out. We have to take, so that is one of the considerations. But we'll
Not feel to take such a decision. This can go on. Once you take that decision, direction can be done. And
just I'm indicating. But the problem is the petitioners have taken a plea that earlier there was an order of settlement that should continue. It is not. It is not.
After change of circumstances,
It is not
Mr.
possible.
Bora has also fairly
Correct.
admitted
Correct,
that part.
correct. That is what I am indicating, sir. These things are dynamic. Manoj.
20
They're
years
changing day by day.
back, these scenarios are very different now.
Entirely different. So
Lordship,
in phase manner, we
otherwise
have to
on
take them
Mary,
out.
the authority which has passed it, it pursuant to an order of the apex court, but the authority which has passed it has no jurisdiction to enter into this area because it is a totally statutorily covered area. No scope for issuing any policy decision or administrative instruction. I can show it from the statute. Otherwise, on Mary,
Lordship has kept it part.
But it is court.
It is demarcation law. If he has filed an application to traffic officer for demarcation of his land.
And it is to the petitioner. Where state council president. Even in the last occasion, there was no representation on behalf of the interest of justice. After his adjourned on medical it is however made clear that in case of murder, not represented on behalf of the petitioners. This court may pass necessary.
Thank you, but first week of December, barring fourth minor, Lordship may fix any date for disposal.
What's the matter?
What's the matter?
Cancellation of license, PTF. Property.
PTS.
Fine.
Who are you? Madam?
Petitioner, right?
Yes. Yeah, Lordship, I'm
Is
not
the
a
cooperative
petitioner.
side,
Yes, Lord.
your PTS license cancelled
Yes, Lord.
after an inquiry.
Yes, Lordship.
What was the charge? What was the charge?
Sir, Lordship, on 7/9/21, an inquiry report against Rangpur Cooperative Society Limited releasing some anomalies made by one shop agent.
What the anomaly we are trying to understand? What is the charge? Selling the goods in the open market meant for PTS. Mr. Goswami? Selling in the open market.
Yes. In fact, today I have not come prepared. That is why I met. They are also not in a position to do the case matter. But we may fix it for final disposal. We need it first week of December.
Shortage of rice. that pretty have been exchanged and matter computing. Please for it on
First of any that subject
on 7th of
yes.
7th.
Right. That's right.
This matter relates to ex gratia compensation, my lord, since the petitioner's son expired due to motor accident, my lord, and there is a government notification. So as per the notification, 2 lakh.
Yes, your
But the accident was actually held in.
no, your response you have not filed.
No, Lordship, actually wrong party is there, Lordship, because it is accident was held in Golaghat district. SP Golaghat is not a party here. So
It's not necessary. Report may be called for, that's all. And the
because
petitioner is
I have
residing at
received one instruction
Nagaon
from,
itself.
from the SP Nagaon. He informed that there is no accident in the.
No, it's not in Nagaon, it is in Bokakhat, but a report may be called for in some other.
Call for from whom?
From Bokakhat PS, my lord.
Who is the respondent?
he is not
Respondent, it is not here, my lord.
Yeah.
Even then, if your lordship, please just to dispose of the matter, my lord, directing or they may do all these things, my lord, because this person's, my lord, son is the expert and all along.
This is not the only unique case. There are hundreds of cases. We don't want to open a floodgate. We do not know how many such of the claims are fake claims. In fact, we are having grave doubts on this ex gratia thing. When you have the avenue of MSCT, why do you need ex gratia? Tell me. Haven't you filed an MSCT claim?
Yes, no, MSCT claim is
Then
there, but
this is windfall, nothing else.
since this is government policy, my lord, that is why my
Policy was for another matter, killed by extremist violence.
and
Another color has been given.
Yes.
It has to be linked with some extremist violence.
that part, my lord, I do not
If
know.
you link with the original notification, that was only for extremist violence. Then the matter arose when there will be a bomb blast in a public bus. Then what will happen?
That is, my lord, of course,
You make the appropriate respondent party.
lordship.
If you are entitled to by the policy, you don't have any issue.
That's true.
But we have to be satisfied that the preconditions of the policy are being satisfied, are being fulfilled.
Yes, my lord, that I can make the part.
In the other one,
Same.
Lord.
same.
Same.
PH3 current conflict appearing for the petition accept. Submit. Appraise for a liberty to file necessary IA to implement respondents. The state submission has been made in view of the objections raised by and Kusami Learner State Council by who has submitted that the accident alleged had occurred in the district of Golaghat.
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 At Golaghat.
And the concerned official of Golaghat district has not been made party.
2 cases are same.
Yes. 2 weeks time. Is it possible? 2 weeks?
Yes, yes.
600 weeks.
In this case also.
Made visual.
Temporary I make.
4th December. Not 4th, but 7th December.
If possible earlier, Lordship, the property of
4th December is difficult.
Oh, sorry. 5th December.
5th December.
Earlier one is 7th.
7th December. What's the matter about?
Lordship, the property of the petitioner has been seized without any show cause, without any authority of law. The petitioner is in an NGO. They are running a halfway home for mentally ill persons. It is a welfare scheme under the social welfare department.
What is the subject matter of seizure? What has been?
Nothing. Documents were seized and the complex has been put in a lock and key with red clocks and saying that it is sealed with effect from May, Your Lordship, without any letter, without any authority of law, Your Lordship.
Proceedings otherwise have been proceedings have been
Except for the fact that, Your Lordship,
where is the affidavit?
Affidavit is there.
It's not here.
SP
Just filed it.
SP filed an affidavit saying that he has not seized, it is that district
Yes,
administration.
lordship will hear it.
Though it is submitted that the concerned superintendent has filed an affidavit of which, such affidavit of which has not been tagged with the court records compared this as agreed to by the party, as agreed with the party. 5th of December, along with affidavit of
Registry to take the affidavit.
of
Oblige lordship.
My lord, I've gone through the petition, my lord. I filed the reply, my lord. That is not in the record, my lord. So
reply against 2 or 3.
Against 2.
2. Repeated. So far as the affidavit of the respondent number 2 is concerned, a rejoinder affidavit is filed. However, is not tagged with the record.
That was not supplied to us. We are newly impleted respondents. 3 and 4.
That was, they have impleted in November, my lord. I have filed it October.
However, we are having
I may
a right.
supply. I may supply. It was for respondent number 2.
And secondly, our name not shown.
Not shown.
You have filed the IAO.
No, I filed the IA, my lord.
The petitioner has filed a IA to implead us. And it was allowed.
Oh, it was allowed.
Yes,
So where is the IA?
that was allowed.
But have you filed your wakalat of the data?
No, we as a caveator, we have appeared. Earlier. Here is a caveat. So he has served the copies to us. Accordingly, we appeared.
But you are not paid part.
Now we made
Earlier, now earlier, my lord, they were not the party. Since the impugn notice was issued by the municipal board, then
Caveat was the matter.
yes,
You are caveat, but you are not paid part.
not paid. Subsequently,
Yes.
made party, and accordingly we appeared.
That they have for number
3 and 4.
as per numbers
And also file a
who, however, has not served such gender. That of the as a but this one
11.
13, my lord, since there is a urgency, my lord.
there is a date of your convenience.
11th of December.
On
11 December.
Can it be on 5th, my lord? My lord,
I'm
because they are
I'm
the
from outside.
respondents. I am the petitioner. My house has been stopped from constructing, my lord, by the respondent number 2.
He has
on
violated
the-
that rules,
no,
your lordship.
That is
And
not there.
seeking an indulgence
And
of this
my
court.
lord,
What house?
my lord, second floor, my lord, existing house I purchased in 2017, my lord. And second floor I have constructed, my lord. with
Where
a-
do you reside? First floor or ground floor?
No, I reside
Commercial building.
nearby building, my lord.
Is it commercial?
And my lord, since I took the permission, my lord, from the
Doesn't matter, 11.
my lord, the
11th
lordship.
case is pending before the court below. Pending of the court case, my lord, this notice was issued. Cannot be there. This High Court
Can
has
we heard
already
marriage
decided
today,
the
your
matter.
11th of
Lordship. Great.
admission hearing.
Lordship.
Please ensure that your rejoinder is served.
Yes, yes, I can.
Yep, good. Well, in this case, the petitioner actually wants to sell her land, but because of an injunction, she's unable to sell. Well, actually, she is the owner of a plot of land measuring 1 bigha, 1 katha.
Yes, you have filed your response.
No.
Get your response. Madam, your response.
Our case is that, my lord, our
One representation is pending. Case 30 losses. That will be disposed of.
Say that both free and good one, that is state house as well as and border and department of Ireland, then for
disposal of the representation. Press matters. Orders perhaps.
The petitioner, my lord, he was appointed as a sweeper under the CGM Baksa.
Yes.
And in a similar matter, lordship had already decided.
Yes.
My lord, here there is a difference. Initially, my salary was stopped. When I filed the writ petition, they temporarily released me till instructions are received from the High Court and the LR and the Secretary of the Government. My lord, the similar matter which had been disposed of, their lordship had
No,
only.
there he was functioning. Now your discontinuation is also be examined.
Discontinuation only as I am temporarily asked not to report.
After that, that's the subject matter of fairness.
There is one subject matter. Other part matter, till the time I was discharged, whether the salary would be paid. Yes, Lordship.
So far as the claim for salary is concerned, till
I
the
have
time.
seen your lordship's order, my lord. My lord, sufficiently explained, my lord, and the ratio that your lordship has laid down. Look, this case covers, my lord.
So far as the discontinuation is concerned.
Discontinuation also, lordship has reduced sufficient reasons in your lordship's order.
You are
Interfere.
against the post for the transport, but
Madam?
it's the same case. Transport, but
Exactly.
that this post was meant for some other part.
No.
No,
This was the this is the matter.
Lordship will remember this order, your lordship will have a look.
We had disposed of one matter where post was for transport department.
No.
This is not
He was not given petition or something like that. That's the matter.
No, this matter, post were sanctioned, advertisement was published, they participated and selected, appointed, thereafter discontinued. And the issue was, there was a circular of 2012 wherein outsourcing was directed by the government of Assam. For sweeper and
Mr. Kotok is that.
Yes.
Yes.
Kotok was the.
Yes, my lord. My senior,
He's
Mr.
a master
Mohanto,
worker.
yes, he appeared, my lord.
So, in that judgment, my lord, the selection process has been upheld. Everything has been done. Since he was working, the area salary and the current salary were actively.
Covers, my lord. So far, salary is covered, but termination, I am not very sure, my lord.
Termination, my lord,
Because
if
then
you go by the
if
ratio.
that even ratio is there.
Ratio is.
Even if your lordship has laid down sufficient reasons to interfere with termination also, but finance, they were objecting in this matter also, they were objecting.
Who's for the finance? Mr. Bhuyan?
Nothing has come on record from them.
No, there cannot be something else which was already
And here it is
taken
not
in
a,
the earlier.
finance, if I may just want to point out, here it is not a termination. It is a temporarily
understood.
release.
Understood.
That
They
we
cannot have a different sense.
And this is without notice, nothing more, even on procedure it has to.
Cannot have cannot dispose this of. We can dispose this of provided you give us a small tip.
We'll do.
Because we have not heard the fact. We'll close this today. Give us written, or we can have it on Tuesday only for the purpose of having a written.
I think that will be better.
That we can, without hearing, we can just close this and pass it. It is submitted that a matter which is similar in nature has been disposed of. Paucity of time not long. No time. As agreed by the parties, this for considering on Tuesday there by the way. Please come up with just one page note.
Will be. Yeah. Obliged.
I leave.
And the other earlier order, I think you have a copy.
It is.
Yes, we
May I please, your lordship? In this case, lordship, the lands of the petitioners acquired for construction of national highway, and initially some amount has been paid, not satisfied. Accordingly, it was placed before the the Commissioner for Appeal Division, and award has been passed, and he directed to reassess the amount, and Deputy Commissioner also reassessed the amount, but payment has not been released till today. And similar order passed by this coordinate bench lordship.
Yes, instruction, yes.
And order is.
It is instruction will be provided by Resolution number 6, Lord. Please, Lord.
Public Works, who is there?
Yes.
Up here.
Lordship, one order.
Have you got the instruction?
Also
That instruction is covered by the.
Yes, Lordship.
There's no point in holding back this kind of matter.
Only difference, award this is different, but commissioner of everything is same area, same land.
Yes, you get the instruction. We'll have it when there before the vacation. We'll have it on 11th of December. He has given on copy. He has given on copy. I think this is
That is not applicable in this case. That regarding
this Chital Jaidev, who was this? Jaidev? Yes, yes, this. Going to consider.
And
11.
And against the award lordship, coordinate one already passed the order lordship, and that case is different. It was challenged. The arbitration case was filed before the arbitrator. This is not the case actually like that. Lordship. 11th of December.
Which matter? Huh?
I think your lordship are getting up with that.
45 is a contempt matter.
Yes, it's a fresh matter.
Notice to be issued.
Notice.
We wanted all matters of can be taken away at 2 o'clock. You are not there. Is there any other one more matter?
Yes.
46 also.
45. My is 48, 45.
What is that? Who is it? 43?
And 44 lots.
Fresh matter.
Fresh matter, Lord.
Okay, we are having
Yes.
only this matter. We'll instruct this motion wrong.
Yes, sir. Please, your lordship, matter is relating to contempt, lordship.
Yes. Which is the order which to allows to have been violated?
Order dated 26/6/23, let's say annexure 1, page 9 to 10.
Which is the operative part? Here for correction of the revenue record.
Yes, sir.
Your name, madam?
K. Bora.
Keyboard. Who by himself is applicant and regarded not compliance of ordered it with passed by the quoted part-time deputy. The learned council has also referred to the representation dated representation which was dated 31/7 which was received by respondent of 11/8/2023.
May I please, your lordship? The matter is pertains to non-compliance with the order dated 21/8/2023, lordship. Honorable High Court, it was dated to the respondent number 3, lordship, page number 10, lordship. Operative part is page number 10, lordship, para number 4, lordship. Respondent number 3 may be examined the representation dated 21/11/2022 submitted by the petitioner and take appropriate action in the matter as may be permissible.
Paragraph Lordship 4, page number 10, Lordship.
In view of the above,
Yes, sir.
how does it start? The paragraph in view of the above.
Start from page number 9, Lordship, and operative part is page number 10,
Then
Lordship.
which, it starts with.
In view of the above,
Okay, please read, in view of the above.
yes, Lordship. Without expressing any opinion on the merit of the case projected in this writ petition, insofar as the claim of the petitioner over the land is concerned, this writ petition is being disposed by the providing that the respondent number 3 may examine the representation dated jointly submitted by the petitioner and take appropriate action in the matter as may be permissible under the law. But the respondent authority has not taken any action, Lordship, till date. And we are submitted representation 128 August 2023, Lord. Page number 11. For the Deputy Commissioner Kokas. A. Alim Sheikh, Lord.
It is the.
Page 20. Yes. Is the order which is passed in a criminal revision. At page 25 is the operative part that I can release the vehicle by paying 10 lakhs.
Page 20.
25 is the operative part. There's a direction given to the IO that the vehicle can be released of bank guarantee of 10 lakhs. It's a JIMA petition, which was initially rejected. I came up before this court in a 482 saying that the vehicle is only 3 lakhs. Cost of the vehicle is only 2 to 3 lakhs. So 10 lakhs is not the right amount. The High Court at page 27, only to the extent of this of the bond condition, says you can release the vehicle on a furnish of 3 lakhs of a bond. I go back, file an application at page 29 to the DFO. No action is taken. I then file an application before the CGM there, saying that the vehicle is not released in spite of the direction given to the IO. A report is called of your lordships, and at page 37, the report says that if a stranger approaches, we will not be able to release the vehicle. Now, that is in view of the fact that because I was operating the vehicle only from an owner, there's a power of attorney, and the trial court already observes this and takes care of that opinion. That's at para 8 of the order which I just now showed your lordships. Page 24. It already says that it is recognized the fact that I was driving it.
You're agreed by which part?
I'm agreed by the fact that the IO has still not released the vehicle after the order of the CGM at page 36. And the relevant part is at page 37. Yes, I'm agreed by the order of this. Yes, 25. Para 12, which I just read it, your lordship. The IO shall hand over the custody of the vehicle to him on submission of a bank guarantee, which is modified subsequently for 3 lakhs with the information of the concerned court. Further, petitioner shall not dispose of the vehicle.
Is any order passed by the?
Your lordship, I filed an application, but the DFO does not take any action. So I go before the CGM and I file an application.
Where is your application?
That is at page 29. Yeah. This is before the DFO.
The respondent is the DFO, is the respondent.
DFO as well as the IO, because the directions was also given to the IO. So this is the application with the JIMA bond, and the application before the CGM, because this was not acted upon, is at page 30 before the CGM, Gwalpara. And the reasons for non-compliance is 35. 3 lines from the bottom. 35, yes. 4 lines from the bottom. But if a stranger approaches, with the above mentioned orders with a desire to get a Jimma of a vehicle, it cannot be executed at all. The allegation of denying the Jimma of the vehicle is stated in your honor in the instant order totally false. Now he says that because I am operating the vehicle by a power of attorney of an owner, that is already taken care of by the previous order. So there is no dispute in regards to that.
Was to the Jimma would be handed over. Was
Never
it
there.
decided?
Yes, your
Was it
lordship should
made-
come to
was it
page.
made clear by the earlier.
Yes, page
judicial
24,
pronouncement?
the idea of the session judge.
Who was the petitioner applicant there?
Same fellow, same gentleman. He's a power of attorney holder. Lethanson Sangma, page 21. And the part which takes care of that is at page 24, para 8. The allegation is already taken care of. May I just read to your lordship's permission? Page 24, para 8. However, in this case, petitioner is not the registered owner of the vehicle. And I have gone through the power special of attorney that so-and-so executed by the registered owner in favor of the petitioner.
Violation of orders of in a particular praying for case of the who is out of the order of the hearing number MS 05 C 000 that in an application made for there was an order by learned session judge Palpar dated 4/7/2020.
Yes.
Whereby the Jimma was directly handed over on purchase of about 10 lakhs.
10 lakhs.
In the state case, an objection regarding the locus of to maintain the application was also raised, which was taken into consideration, and therefore the order was passed for handing over Jimma. The aforesaid order, however, was modified by this court on 28/4/2002 past 381 of it by reducing amount of bond from 10 lakh to rupees 3 lakh.
3 lakh.
The approach of the petition to get the order executed by funding a bond as modified by the court was, however, unsuccessful, and he refused it was on the alleged ground that the petition is a stranger. Submit that apart from objection raised by the respondent disputing being unauthorized in law after there has been on the issue was also one of the issues was raised and dealt by the court. According to that the actions are and is in violation of order of the court and among on sitting over sitting over in a, on orders and directions of that is court
I'm extremely clear.
rest of the matters, is there any interim order of the matter? If interim order is there, we'll extend it, otherwise, court must have.
Item number 15 and also, I mean, 68 because
We'll give it. If interim order is there, we'll pass on.
I'll